Okay, ready? 1, 2, 3. Hold on now. Wait a minute, fellas. Wait a minute. I think it goes something like this. Whoa. 1, 2, 3, 4, 5, 6. Can somebody take these burdens off of me? Off of me. Can somebody take these burdens off of me? Off of me. Cause every time I turn around, there's something trying to keep me down. Can somebody take these burdens off of me? Off of me. Whoa, can somebody take these burdens off of me? Off of me. Can somebody take these burdens off of me? Off of me. When I look up, don't you know, burdens knocking at my door. So won't you come and take these burdens off of me? Off of me. Oh, come and take these burdens off of me. Off of me. Somebody come and take these burdens off of me. Off of me. Soon as I get up off the ground, my burdens knock me right back down. Can somebody take these burdens off of me? Off of me. Somebody take these burdens off of me, off of me. Somebody take these burdens off of me, off of me. Somebody take these burdens off of me, off of me. Well, off of me, off of me. Oh, off of me, off of me. Well, off of me, off of me. Get them off of me, off of me. Come and break the chain. Come and break the chain. Off of me. Get it off of me. Off of me. Get it off of me. Off of me. I need somebody. I need somebody. I need somebody. I need somebody to get this burden. To get this burden. Can somebody take these burdens off of me?
Hey guys, how are you guys doing? Hold on, let me get my other guests. Hey, Perspective Me. Hey, T.
Hey.
How's everybody doing this afternoon, guys? How you doing?
Great.
Doing
Great. Doing good.
Shout out to my co-host this afternoon. These ladies have decided to take some time off and to help a sister out. All right. Here's why we're here this afternoon. We wanted to bring some things to you guys' attention, for you to be aware. We are not attorneys. We do not know the law. So I'm just going to put the disclaimer out there. This is just information purposes only. Just to bring out some things that were mentioned in court, as well as other prior interviews that was done. So what we're doing is trying to jog your memory a little bit, just to help you guys out in remembering some things that occur during trial, prior to trial, and after trial. So without further ado, what I'm going to do, I'm going to play interview from 1 second, y'all. Hold on. My apologies. That was Miss Dallas. She wanted to find out if I had something. Well, anyway, without further ado, I'm going to play an interview that with Robert's attorney, and I want you guys to listen to some key things that she mentioned. And this is an interview with Jennifer Bongine, and it was with the BNC News. So I know some of you guys remember this interview, but listen closely to this interview, okay?
Okay, Jennifer, so I'm going to start this conversation by asking you the most obvious question, one I'm sure you get all the time. Why would you defend R. Kelly?
I approach every case the same way. And I look and I say, has there been a miscarriage of justice? And in my mind, a miscarriage of justice occurs when the government oversteps, when they overreach, when they violate someone's constitutional right to a fair trial. And then I ask myself, is there anything I can do about it? Can I possibly get this individual some type of remedy, some type of relief? And when I looked at R. Kelly's case, I found that both of those things were true. And so I had no reservations about taking R. Kelly's case. What I see was a travesty of justice and how the process worked. And when the process doesn't work, the outcomes are not fair, they're not righteous. And as a result, I took R. Kelly's case. And I pass on cases, but this is a case that I felt satisfied both of those requirements.
Did you hear what she just said? She took on the case because, in her own words, there was a travesty of justice. Justice was not done. It was unfair. It was unfair in Mr. Kelly's case. And we're going to point out some things that we as laymen, regular people, saw that was unfair in Mr. Kelly's case and how the government got a conviction. Okay, here, I'm going to continue playing this. And then after that, we're going to bring some stuff that we dug, did our own research, and we're going to present it to you guys. Okay, hold on.
And that's because you think that the government abused the Rico statute in order to get around issues of statute of limitations, right? And so for people who may think I'm talking legalese here, there were accusations for decades against R. Kelly. Those accusations, cases, whatever it may be, were old, and so they couldn't be tried in a court of law. But to get around that, prosecutors use this statute, the Rico, which most people would associate with like big drug lords, to get around that in order to get R. Kelly on these charges. That's what you're talking about when you're talking about a miscarriage of justice, correct?
I mean, it's more than that. First of all, the government could have charged R. Kelly along many years ago, many times over, with whatever crimes they believe that he committed. Now, they didn't do that many times. We know there was a case back in I think in the mid-aughts out of Cook County, and he was found not guilty of that case. But the government could have brought charges, and they chose not to for whatever reasons. And now they have brought charges against him under Rico, which, yes, was designed to get at criminal enterprises, mafia, large drug operations run by gangs. And they are doing that, yes, to plead around the statute of limitations. But even more problematic in my mind is they use this statute in order to overwhelm the jury with other crimes evidence or other bad act evidence. It doesn't even have to be another crime. So really what they're doing is putting someone's life on trial. And that ends up being not really a fair fight. It's one thing to defend against a specific charge. That is fair. But when you bring in these crimes, these alleged crimes under the RICO Act, you're really putting someone in a position where they have to defend 30 years of their entire life. And that, I think, is not a fair fight, because it doesn't give, you don't have fair notice on what they're coming at you with. There's allegations that date back 30 years. And there are sometimes it's very difficult for particularly high profile people. 30 years. Do I even know this person? Where was I? How can I defend against that? So it's not a fair fight. And then they brought claims under the Mann Act. And the Mann Act has been historically problematic, and it was no less problematic in this case as well. So I believe that the government misused those statutes in order to gain convictions against R. Kelly that were not fair. And there's much that the jury didn't hear that they should have heard.
Jennifer, I'm a lawyer too, so I understand what you're saying, and I'm able to think about this in a logical, obviously legal way, setting aside my emotion. But for the lay person, the person that's watching right now, and who's watched our coverage of R. Kelly's trial, who believe that he's finally being held accountable for abusing Black women and girls, they don't care about a fair fight, right? They be creative. They're probably thinking, hey, however way the government could do it, they finally did, and it's done. I don't care. Explain why it matters to everyone ultimately that we essentially, there's a checks and balances when it comes to prosecution.
Yeah, that's right. And I can appreciate that there's emotions that run high and people don't necessarily value how the government goes about getting what they consider to be justice. But when the government runs amok, right now it's R. Kelly, tomorrow it's somebody else. And maybe it's someone you care about tomorrow. Maybe it's a loved one of yours. To keep the government honest and to keep them in check, the system has to work for all of us. The R. Kellys of the world, the Bill Cosbys of the world, and then people that we don't even know. And so my job is to make sure the government does it the fair way. And if they didn't do it fair, it just doesn't count. It's like if you cheat during a football game and you want to declare victory, you can't because you cheated. And it is my job to hold the government responsible and to hold their feet to the fire. And I believe that was not done. It hasn't been done, but we're hoping to do it.
So, I've had this conversation with colleagues for years. And in fact, we had a conversation about it on the show a few weeks back about the blowback that attorneys risk facing from the public over who they choose to represent. I get tweets from viewers asking why I keep inviting certain lawyers who represented less than desirable clients. And of course, that question that we all get, defense lawyers get, how can you defend a guilty person? I'm curious, how would you respond? What would be your response to that question?
Well, I first of all, let me start by saying that that is a general question I get all the time. I don't know whether it's specific to R. Kelly or not, and I'm not here to, I don't trust the verdict that came back in R. Kelly's case. So I'm not going to say he's guilty until I believe that there was a fair process. I don't rely on verdicts where the process was not fair. So let me make that clear. I do not believe that the verdict is a reliable indicator of whether R. Kelly is in fact factually guilty. But to your general question of how do you represent unpopular people? How do you represent people that the media has already convicted? How do I represent them? I'm a defense attorney, and that's what I do. And I believe to my core that the government needs to be held needs to be held accountable. And when they don't go about this process in a fair and just way, that is a miscarriage of justice, and it affects all of us. And I guess I just really believe in that principle. It just doesn't matter to me whether it's R. Kelly or Bill Cosby or any number of wrongfully convicted people that I have represented over the years. It just does not matter. It's all the same to me, because if the system doesn't work for one, it doesn't work for any of us. And I guess I'm just really focused on that principle. And it doesn't, my view is if you're a defense attorney and you can't get with that idea, then maybe find a different career. It's really one of the fundamental tenets of what we do.
Okay, all right. Thank you so much on that one, Jennifer. Before we get started, do you ladies have anything to say in regard to what we just heard?
I just typed it in the chat that I love that Jennifer Bonjean stated on record that she does not believe that he's guilty, and until they receive a fair trial, she's not going with that narrative.
Mm-hmm. So. Tanya?
Yeah, I feel the same way. If you just read into her words and what she was saying, a lot of people probably missed that. I think her angle is going to be to beat the law with the law. And she's going to fight them with the law, all the violations and all of that. So I just think he's coming home. So
I do too. There's some words that she basically used. She used terminology like the government cheated. She says she didn't trust the verdict and the process, how they got there, and it was not fair. She also said that media had already convicted Mr. Kelly. And then she also mentioned how, if it happened to them, who to say it won't happen to you? Because if you're doing any kind of tactics, unfair tactics of trying to get a conviction, how fair is that? She also mentioned how, they use 30 years of his life. Who's going to remember everything that happened in their life 30 years ago? Do you remember what you ate 30 years ago?
I recognize she said, and they didn't give him proper time to be able to combat those accusations. And we all know that to be true because the what is it called? The discovery wasn't released timely.
And then he didn't know who the accusers were. All of them were not mentioned who they were. They didn't get that information till right before trial. They gave a scenario, but didn't give directly who they were until right close to trial. The other thing that the lady talked, the questionnaire, she was saying how, people saying that it doesn't matter how they got him as long as they got a conviction because it was so many years of supposedly these acts was happening, right? Now, here's the thing I wanted to bring to everyone's attention. That the Prior Bad Act, what is Prior Bad Act? According to the definition of Prior Bad Act, it says here, Prior Bad Act is basically, one second. Just gonna bring it up. Hold on. I should have had it ready. Okay. Prior Bad Act is defined as taking place prior to trial, so they can take place after the arrest of the offense being tried. It's basically testimonies of wrongs that cannot be proven. You hear that? Testimonies of wrongs that cannot be proven or which are barred from prosecution by statutes of limitation. So they allowed Rico in to bring in the Prior Bad Acts because normally those acts could not be prosecuted because it's past the statute of limitation. And you got to also remember there were never any police report. There's never been anything proven that he actually did those acts. It's one person's word against the person that's being charged, right? There's nothing, no evidence of these things happening. I'm talking about the Prior Bad Acts, those individuals. The government allowed Jane Doe's and two John Doe's from number 7 all the way up to 22, right? This is tried to tank the jury's mind, and it's also done as it was prejudicial, meaning that it caused some prejudice, even though he is not being charged with those acts. The jury is going to look and see, hey, there's like almost 22 people saying this stuff, so it must be true. So therefore, it tainted the view, even though they said not to use it as a big barrier, because what we're going to do is going to show you not show you, but tell you about the jury charge and what the instructions were from the judge for them not to pay attention, but they allowed it to come in. Does that make sense to you? You say not to pay attention to something. It says, okay, somebody say, okay, don't look at the elephant. Then you put the elephant in there, and then you say, don't look at the elephant. Don't look at it. You're going to look at the elephant because it's a big old huge elephant sitting in the middle of the table, right?
Yeah, and because we're human, we can't unhear something.
That's true. That is so true. We can't unhear it. No matter how many times they say, don't listen, strike that. You're going to, I guarantee you there was a juror that wrote that little note in there. So it was prejudicial. It was, they were prejudiced against Mr. Kelly from the beginning. And also you bringing in someone like Aaliyah. Remember, he was not charged with with anything having to do with underage things, having relationship with her. He was charged with the bribery, right? But what did they do? They brought in someone, Jane Doe number 7, to discuss the alleged sexual abuse, which is never been proven, it's never been verified. That's another way the jury was tainted because they allowed that person to come in and testify. Okay, so that in itself is prejudice against the defendant.
And then Bonjean mentioned that today it's R. Kelly, but tomorrow it can be your family member. Basically, she was saying this case is setting precedents. And once they try a case like this, they can continue to try cases this way because judges and lawyers go off of, what is it called? Case law.
Mm-hmm.
Where once a case is tried this way, they can reference another case to say, we can do this because this case went this exact way.
Absolutely.
So it is setting precedents.
Yep. So now what we're going to do is I'm going to have the ladies to read the prior bad acts of those individuals from 7 all the way to 22 so you guys can hear. And what the jury instruction, we're going to talk about the jury instruction on those prior bad acts and see what happened, how they came up with the verdict. But remember, he was only charged for 6 individual, only charged for 6. He wasn't charged for the 7, 8, 9, 10, 11, 12, 13, 14, 15, all the way to 22. He was not charged for that. Okay, but they used those testimonies and those information from those people to get a conviction because they're saying if he did this in the past, then the likelihood of him doing this is probable. Okay, even though those cases were never proven. Never proven, no police report, none of that stuff happened. But they use it as a reinforcement to try to get a conviction, which is what they got, which was unfair tactics. And remember, they did not allow Mr. Kelly to have his real say in it. He didn't allow character witness. They didn't allow them to come and say anything good about him. They did not allow that. So that in itself was unfair practice and his rights were violated. And this is layman's. This is not, we're not attorneys, but we're just going to show you what it was said. Whichever one wants to go ahead on and start, go ahead.
Okay. Tanya, would you like to start now because of?
Yes.
Okay.
No, you go ahead because they're here. So.
Okay. So we're going to start at sexual abuse of Jane Doe number 7.
Hold on a second. Let me tell you guys, I'm not putting it up on the screen because I don't have my watermark on it. So just follow along with her. All right, go ahead.
Okay. In or about 1991, when she was approximately 15 years old, Jane Doe number 7, an individual whose identity is known to the government, met Kelly at his apartment in Chicago, Illinois. Jane Doe number 7 had been invited by a female acquaintance who was also a minor to come to Kelly's apartment with her. 2 other minor females also came to the apartment with them. While at the apartment, Kelly initiated and engaged in sexual intercourse with Jane Doe number 7. Jane Doe number 7 also saw Kelly engage in sexual encounters with other minors she went to Kelly's apartment with. Jane Doe number 7 later became employed by Kelly as, among other things, a backup dancer.
Okay, one second. She supposedly was 15, right?
And can we say who this was?
Yeah, you can.
Okay, so this is Javante Cunningham. And I don't know if any of you guys remember in Surviving R. Kelly, she said that she had not slept with him. So
But
I just want you to keep that.
She changed her story now when she got on the witness stand. So there's a contradiction in her testimony then.
Okay. So during the course of her time with Kelly, Jane Doe number 7 observes Kelly engage in sexual contact with Jane Doe number 1, a minor.
We go right there where they bring in Jane Doe number 1. Jane Doe number 1 is supposedly be Aaliyah, right? Remember when I just showed you the other day when Aaliyah's mother herself said there's no such thing happened. There's no such thing that happened. So why are you willing to take a word of someone who said one thing, then change around and say something else? And Aaliyah, if you guys could remember, she never, ever, ever admitted to any of this when she was asked. There was never charges placed on Mr. Kelly or anything like that. So for her to even come out and say something like this, why is it that they're taking that person's word and the person's not even alive? But see, the tactic that the government used was unfair.
Yeah, I want to say Aaliyah's mom released a statement against this person, saying she's never seen her before and she's a complete lie.
Hold on a second. Go ahead and read it. I'm going to bring up Aaliyah's mom's statement on what it said.
Okay. So in or about September 1994, Jane Doe number 8, a 17-year-old girl and an individual whose identity is known to the government, attended a concert in Florida where Kelly performed. After the concert, members of the enterprise directed Jane Doe number 8 and a friend of hers to go backstage to meet Kelly, and Jane Doe number 8 obtained Kelly's autograph. While Jane Doe number 8 was backstage, Kelly, who was not wearing a condom, vaginally penetrated her with his penis in violation of Florida law. A pamphlet signed by Kelly containing a reference to Jane Doe number 8 and a room number corroborates Jane Doe number 8 encounter with Kelly. Okay. So I'm on. She says she was 17. She went to get an autograph and he had sex with her in the back room, and she kept a signed autograph in his room number as evidence over the years. She never complained, never made a police report, but she's speaking to the fact that she's saying they slept together. Okay. D. In or about 1995, Kelly met Jane Doe number 9, a 17-year-old girl, and an individual whose identity is known to the government at a Florida mall, and thereafter commenced a sexual relationship with her in violation of Florida law. On one occasion, Jane Doe number 9 laughed at a joke by one of Kelly's associates, and Kelly immediately summons her outside and slapped her across the face for having done so. During their relationship, Jane Doe number 9 contracted herpes and disclosed her diagnosis to Kelly, who did not admit to having herpes at the time of her diagnosis. Jane Doe number 9 was only sexually active with Kelly.
Okay, 1 second. Let me just go ahead on and play this from Aaliyah's mother. This is somebody reading this. Shout out to Sweet Tea TV, I think. All right, let me play this.
According to a source, Diane Huntington said in a statement that the woman and the so-called backup singer that described seeing, meeting, or ever breathing the same air as her daughter, Aaliyah, that they are lying, but they both are liars. She says that my husband and I was always on tour with her. We went to all of her interviews with her, every place she went throughout her entire career. We were always present. Whoever this woman is, I've never seen her before anywhere on the planet Earth until now. And in my opinion, Mrs. Diane Huntington, you are...
Okay, this is lady giving her opinion, but this is what Diane says in regarding to Javante's statement on this. And here's the deal. Why is it that she said it on the stand, 20 years later? Why didn't she say something earlier? This is the thing I don't understand with these people. You have this story and all this stuff that you claim happened. Why you didn't say it before?
Why? And doesn't that Wouldn't that make you an accomplice or a complicit if you witnessed these crimes and yet you never spoke?
Never spoke about it. Even when she was talking all over the place, she never mentioned anything about her being in a relationship or even having some inappropriate relationship with Mr. Kelly at all.
I wish we could go and play her portions from Surviving R. Kelly to show her statements in there, because
And hold on.
okay, because those are very contradictory. Hi, chat. How are you guys? I don't get Javante. Also said she saw R. Kelly and Aaliyah having sex on the tour bus, but on the stand, she changed it to apartment. I don't think she changed it to apartment on the stand.
Yes, she did.
Did she? Oh, okay.
She said apartment.
Well, look at that. Another contradiction. The girl is just a liar. For some reason, I thought it was the other girl she said was in the apartment. Copyright. Who is number 7? Javante. Do we know who number 8 is, Sylvia?
You got to read it and then I'll let you know. Hold on a second.
I don't think I remember who 8 is. I believe number 9 is what's the Lizette Martinez. So she's the one who has the book out, who became homeless after the fact and only got around $1,000 from being on Surviving R. Kelly.
I know that what's the name's number 9? Lizette's number 9.
That's what I was saying, number 9. But number 8 is the one who said she went backstage to get an autograph and he had sex with her. I'm not sure who that was, though. Oh. Number 9 is Lizette. Number 8 is unknown. Dolores, did he say he's seen it or he heard it?
What happened? I'm just trying
Dolores said something about Sparkle's ex-husband, saying what he said on his interviews, but did he say he's seen it or that he heard it? I thought he said something about hearing something through a vent. And then he sent his wife to work with Kelly and live on the couch. Does that make sense to you, Dolores? He was talking to Andre. Yeah, I seen those the public announcement interviews.
Okay, I got her message, her thing now. Hold on.
You're aware and you're not saying anything. You're just as sick as he is. Please understand that. Doesn't make you any better because you're not doing it. If you're aware and you're not saying anything, you're just as sick.
You had.
Hold on, hold on.
I agree with you, Anthony. So yeah, I think we should try to find everyone's motives and have a video of motive.
Oh yeah, that would be a good one.
That's a good one.
That is a very good one. But go ahead. They took all of those interviews down. They took it all. I was looking for it.
Okay.
Fontes, and
Well,
I can't find it.
okay. So I'm gonna start back at Jane Doe number 10. In or around July 2001, Jane Doe number 10, an individual whose identity is known to the government, who was then 16 years old, attended an R. Kelly concert. Prior to the concert, a member of the enterprise gave Jane Doe number 10 and her friend backstage passes so they could meet Kelly following the concert. After the concert, Jane Doe number 10 and her friend Kelly met Kelly backstage and took a photo with him. As they were leaving, another member of the enterprise told Jane Doe number 10 that Kelly wanted to see her again and provided her with a piece of paper with Kelly's cell phone number and his hotel room number on it, and advised Jane Doe number 10 to call the phone number in an hour. Thereafter, Jane Doe number 10 called. She called, you guys, the number, and Kelly invited her to come to his hotel room. Jane Doe number 10 subsequently went to the hotel room with her friend. When they arrived, Kelly was there with multiple other people. Kelly subsequently took Jane Doe number 10 to the bathroom, closed the door, and immediately exposed himself.
You know,
signaling
right? That's the Baltimore girl, supposedly.
the Baltimore girl. The light-skinned ones who showed LL Cool J?
Mm-hmm.
Okay. Okay. Kelly subsequently took Jane Doe number 10 to the bathroom, closed the doors, and immediately exposed himself, signaling that he wanted Jane Doe number 10 to give him oral sex, which she did. Jane Doe number 10 and her friend subsequently left. The next morning, Jane Doe number 10 returned to Kelly's hotel room. I don't see the force, the kidnap, but okay. Returned to Kelly's hotel room, and the two engaged in sexual contact. Thereafter, Jane Doe number 10 communicated with Kelly by phone and through another member of the enterprise. Kelly made arrangements and paid for Jane Doe number 10 to travel to Chicago to see him.
Well,
And
I don't recall them saying that she travels to Chicago in an interview with Okay, sorry, my bad.
in or about December. I'm sorry, go ahead.
No, I said my bad.
Oh, okay. In or about December 2001, while Jane Doe number 10 was 16 years old, Jane Doe number 10 traveled to Chicago to Kelly's recording studio. Who booked these tickets, and can you do that without a parent?
16? No.
I didn't think so.
'Cause I had to pay for my when my daughter was traveling when she was 17. I had to buy her ticket. She couldn't buy the ticket on her own.
So makes you question, right?
Mm-hmm. A parent had to be the one to buy it. So I don't.
Exactly. Okay, so she was 16 years old, and we haven't stated that all his concerts are 18 and above.
Yeah.
No children should be there.
Yeah.
So anyone coming backstage for autographs and so on and so forth, the expectation was that they were 18 years old. And I believe they called that out on the stage. You have to be 18 years old and older to come back here.
Even when he was, if you see the old videos, you see a sign, somebody carrying a sign has age 18 and over. It had that on the sign. I've seen some old, I've never been to a concert of his, but I seen some of the old videos and I see people walking around with the sign. And plus the conversation and the kind of singing he does.
I mean, I just have to be honest. If a grown man says he wants to see me again, I am not so naive that I would believe he just wants to play Barbie dolls. I know exactly what he wants. So for you to call back, you knew exactly what you were going to, and I'm not saying that that's making anything okay, but I'm just saying these girls knew the intent. If this is the case.
Here's the thing. Okay, everybody said, "Oh, he's a grown man. He knows better, whatever." If I have a concert and my concert says everybody in the audience should be this age, why would I not think that you're at age?
Exactly.
Why would I not think? Why would I have to say, oh, is she 12, 13, 14, 15, 16? No, but my concert says that you have to be 16.
Just like if you're in a 21 and up club, I have the expectation that you're 21. And if I tell my security no one is supposed to come back here unless they're 18 years or older, and I'm paying security, no one's supposed to have gotten past that area without being of age.
And why didn't the security come in and testify? Why didn't they bring all the security, every single security person?
Right. Where is this enterprise?
Why didn't I hold responsible? Let me tell you something. When you do a crime at a company, the company's not taking your crime responsibility of crime. They're gonna fire you behind, and you're gonna go for that crime on your own.
While they're saying a member of the enterprise did this, a member of the enterprise did that, not once are they bringing out these members who supposedly gave these tickets, who gave these telephone numbers, and so on and so forth.
True.
Okay. So Kelly immediately told Jane Doe number 10 to pull down her pants and turn around. Jane Doe number 10 did not initially comply with Kelly's directions. In response, Kelly became angry and yelled at her. Jane Doe number 10 felt intimidated and did as Kelly directed. Therefore, Kelly asked Jane Doe number 10 for her ID, and she showed it to him. Kelly therefore directed Jane Doe number 10 to give him oral sex, which she did. In April 2003, when Jane Doe number 10 was no longer a minor, Jane Doe number 10 saw Kelly again and engaged in sexual intercourse with him. Let's see. So I just want to see from which year to which year. She started in 2003 and went back and seen him she started in 2001 and then 2003 went to see him again.
Which is what, 18 years later?
No, it's only 2 years later.
No, I'm saying 18 years later they charge him with it. I'm saying.
Oh, okay. But we're not done yet. He still continues to go. Hold on. So 2003, he had intercourse again, and then, or about 2004, based on information she received from another individual, Jane Doe number 10 became concerned that Kelly may have videotaped their sexual encounter in his hotel room when she was 16 years old, and that such a videotape had been disseminated. In an effort to learn whether such a videotape existed, Jane Doe number 10 contacted lawyer number 1. Makes me want to ask why she contacted a lawyer instead of calling and asking him, who had represented individuals who had sued Kelly previously. Thereafter, Jane Doe number 10 engaged the services of lawyer number 1. Kelly ultimately reached a financial settlement with Jane Doe number 10, in which he paid a substantial sum to Jane Doe number 10 and the lawyer. The settlement agreement included a non-disclosure provision, which purportedly would prevent Jane Doe number 10 from reporting Kelly's conduct to the law enforcement.
Really?
Didn't Koenig go over these non-disclosures that really did not say that?
Mhm.
Okay. Exposure, no, let's see. Jane Doe number 11. An individual whose identity is known to the government met Kelly when she was an adult and had a consensual sexual relationship with Kelly beginning in 2001.
Let me
Prior
tell
to,
you, hold on a second. She was supposed to testify, Nika. She I don't know how, but she did not show up because they were supposed to do even a video interview. I mean, a video testimony. They didn't even do that. They didn't even do that. So I don't know. Can't even answer you that.
Okay, so Jane Doe 11, an individual whose identity is known to the government, met Kelly when she was an adult and had a consensual sexual relationship with Kelly beginning in 2001. Prior to engaging in sexual activity with Kelly, Jane Doe number 11 tried to ask Kelly whether he had a sexual transmitted disease, and he demurred. Okay.
Here's the other thing. You meeting a superstar, right? You're an adult. It's your responsibility to make sure you're protected. Why would you sleep with somebody that's not your husband and you just meeting? I don't get it.
So the next sentence says Kelly did not want to wear a condom while engaging in sexual activity with Jane Doe number 11.
If he didn't want to wear a condom, then I don't. Look, dude, we're not doing it.
Exactly. You're grown. You don't want to do it.
Dolores, no, Susan did not die. Did not get killed. No, that was Mish. That was his attorney that died.
Jane Doe number 11 later learned that she had contracted herpes and believed she had contracted it from R. Kelly. So I wonder why she believed that, as opposed to thinking that anyone else that she had been sexually active with had given it to her. Because, I mean, it just says that she believed, and it doesn't say that she hadn't slept with anyone else. In or about 2003, Jane Doe 11 retained a lawyer, number 1, and reached a $250,000 settlement with Kelly. Jane Doe number 11 advised that her friend Jane Doe number 12, who is now deceased, also reached a $250,000 settlement with Kelly based on a similar claim. As part of the settlement, Jane Doe number 11 believed that she was not permitted to disclose to anyone, including law enforcement, her claims about Kelly. So she believed, but I'm not sure if it was actually in her settlement. No one brought their settlements, right? Only one person had their settlement.
Geronda.
Was it Geronda? I thought it was someone else.
No, she didn't bring it. She talked about it.
One person had it in hand. Everyone else did not have it. Okay. In March of 2006, Kelly met Jane Doe number 13, a 15-year-old girl or an individual whose identity is known to the government, at a concert and arranged, to meet her the following day. Upon meeting her, Kelly asked her whether she was a virgin and thereafter commenced a sexual relationship with her. Kelly arranged for a member of the Enterprise, one of his bus drivers, to drive Jane Doe number 13 several hours within Florida, and otherwise arrange for her air travel to Kelly's residence in Chicago, Illinois. Again, 15. How are they arranging air travel with no adult? Telephone records, emails, and bank records corroborate Kelly's relationship with Jane Doe number 13. beginning when she was 15 years old. What year was this? Telephone records from 2006. In or about December 2006, Kelly met Jane Doe number 1, a 17-year-old boy and an individual whose identity is known to the government at a local McDonald's, and invited him to attend a party at his residence in Chicago, Illinois. John Doe number 1, along with his mother and stepfather, attended the party. When Kelly saw John Doe number 1 with his family members, Kelly advised him to come without them to the next gathering. Thereafter, Kelly invited John Doe number 1 into his studio under the guise of helping and mentoring John Doe number 1 with his musical aspirations. Kelly also asked John Doe number 1 what he was willing to do to succeed in the music business, and clarified that he wanted John Doe number 1 to engage in sexual contact with Kelly. With that backdrop, Kelly then engaged in sexual contact with John Doe number 1 in violation of Illinois law. John Doe number 1 thereafter introduced Kelly to, among others, John Doe number 2, a close male friend who was then 16 or 17 years old and whose identity is known to the government. And Kelly sought to establish a sexual relationship with John Doe number 2. Several years later, Kelly started a sexual relationship with John Doe number 2 and required his girlfriends, including Jane Doe number 5, to have sex with John Doe number 2 upon his command, and often filmed those encounters. Kelly sometimes paid John Doe number 2 after sexual encounters with him. Now, are we gonna mention who the John Does are?
Yeah, you can.
Okay, so John Doe number 1 is Richard Arline, who was he was charged with bribing Azriel, and he was offered a deal in order to testify. And his testimony kind of collapsed because Koenig pointed out that he was only doing this in order to lessen his sentencing. And he's also a married man. What else can we say about him?
Oh, he's the one who's claimed that he knew somebody that worked in the who was one of the jurors in the 2008 case.
Okay.
And then the other one is Nephew. The guy they call Nephew. His name, I forgot his real name. Oh, I can't remember his real name.
I can't remember it either, but I know he also had some charges. He also had stolen from R. Kelly. I think he was angry about someone not bailing him out, but in reality, he was bailed out. Richard Arline had stolen the money.
Okay, she said, did they show any of these taped event in court and they find any of these videos? No.
No.
Nope. What we're going to do, we're going to play something. We're going to read something else for you guys, but she just continued. Oh, you finished all of them, right?
No, I'm going to finish reading John Doe number 2.
Okay.
Okay. Government, John Doe number 2, later. And I'm sorry. Telephone records corroborate Kelly's relationship with John Doe number 1 and John Doe number 2, beginning when both were 17 years old. Didn't they say earlier in this that it was when he was 16? But now they're saying 17?
Yeah, they did. But okay.
John Doe number 1 also introduced Kelly.
According to Chicago, 17 is age of consent.
Yeah.
Just in case somebody want to know.
Also introduced Kelly to girlfriends of John Doe number 1. John Doe number 1 introduced Kelly to girlfriends of John Doe number 1. Okay. In 2008, Kelly met John Doe number 14, a woman in her 20s whose identity is known to the government, and arranged for her to travel to Kelly's residence in Chicago, Illinois, where they began a sexual relationship. During her last trip to Chicago to see Kelly, she was left in a room for a long period of time, and she became worried. She told a member of the enterprise, an individual on Kelly's security team, that she wanted to leave, and that individual said they would figure it out. The following morning, okay, this is the one. Okay, the following morning, she overheard Kelly yelling and sounds of physical assault. Jane Doe number 14 again contacted Kelly's security team, but this time she was told, this time said that she was going to call the police if not permitted to leave. Only then did the member of Kelly's security team come to the room where she was staying, escort her out of the room, and take her to the airport.
So y'all know who Jane Doe supposedly of 14 is, right? Supposedly, what did we say earlier?
Portia.
I'm here.
Williams.
I'm here. That's Portia. Mhm.
Portia, okay.
Okay. Tanya, you want to do any? Or you still want me to keep going?
Just give me about 10 more minutes, but yeah, you can go ahead. They're about to leave in a second.
Okay. In 2009, Kelly met Jane Doe number 15, an inspiring singer who was 17 years old and whose identity is known to the government through a talent manager who years later became an employee of Kelly, identified her herein as employee number 1. Kelly paid for Jane Doe number 15 lodging at a hotel nearby his residence in Olympia Fields, Illinois, purportedly so that Kelly could mentor and assist her with her music career, and Jane Doe number 15 could use the studio at his residence to record music. Jane Doe number 15 ceased her relationship with Kelly when she was 18 years old, went to the hospital where she confided to a nurse that Kelly had sexually abused her, filed a police report, and retained an attorney, lawyer number 1, to represent her in a possible lawsuit against Kelly. Kelly thereafter told employee number 1 in substance that Jane Doe number 15 was attempting to sue Kelly for engaging in a sexual relationship with her. That employee number 1 needed to decide whether she was on Team Kelly or Team Jane Doe number 15. And that employee number 1, who was based in Atlanta at the time, needed to travel to Chicago immediately. At Kelly's direction, employee number 1 traveled to Chicago, where Kelly told employee number 1 in substance, "You have to be careful in these situations because people end up going missing." A comment employee number 1 construed as a threat to her and her family. Shortly thereafter, a member of the enterprise, one of Kelly's employees, told employee number 1 that she had to go to downtown Chicago with him, but did not provide any information regarding precisely where they were going or for what purpose. Upon their arrival in downtown Chicago, employee number 1 was dropped off at Kelly's lawyer's office, where the lawyer presented her with a prepared typewritten affidavit to sign. Employee number 1 did not read the affidavit in full, but saw that it said, enter Alia. Enter ALIA. I'm not sure what this word is. And in substance, that she did not see Kelly have sex with Jane Doe number 15, provide Jane Doe number 15 with alcohol, or slap Jane Doe number 15. Employee number 1 reported that she signed the affidavit without carefully reading it because she feared that harm would come to her or her family if she did not. Bank records show that Kelly paid lawyer number 1, and the lawyer number 1 then paid nearly $400,000 to Jane Doe number 15. Jane Doe number 15 has repeatedly declined to meet with the law enforcement. In or about 2001, Kelly met with Jane Doe number 16, who was then 16 or 17 years old and whose identity is known to the government, and commenced a multi-year sexual relationship with Jane Doe number 16. In or about May 2009, Kelly met Jane Doe number 17, who was then 17 years old and whose identity is known to the government, and commenced in multiple year sexual relationship with Kelly. Both women remained with Kelly until at least in or about 2017. Kelly regularly spanked Jane Doe number 16 and Jane Doe number 17 when he perceived that they had violated one of his rules. He also directed Jane Doe number 16 and Jane Doe number 17 to write numerous letters containing falsehoods and embarrassing allegations for Kelly to use at his discretion if and when the need arose. In addition, witnesses saw Kelly subject Jane Doe number 17 to particularly extreme punishments, which included loss of her cellular phone, violent assaults, and deprivation of food, and the ability to leave her room. Jane Doe number 16 and Jane Doe number 17 also engaged in sex with Kelly and John Doe number 2, an individual otherwise unknown to either of them. At Kelly's direction, which interactions were often filmed. The government recovered various letters written by Jane Doe number 16 and Jane Doe number 17, including certain ones that appeared to contain falsehoods. Now, I know all this sounds bad, people, but once you see the contradictions and hear all the lies that were exposed about these people who made these claims, then you'll understand the point of us reading this.
Okay. We want to be totally transparent with you guys, totally transparent. So now, as we were speaking, are you finished reading? I'm sorry.
No, there's a lot to go.
Okay, go ahead.
Okay. In or about 2016, Jane Doe number 18, whose identity is known to the government, met Kelly at one of his concerts when she was approximately 20 years old. After one of Kelly's associates approached her and told her, Jane Doe number 18, that Kelly wanted to meet her. In or about 2016, Jane Doe number 18 started a sexual relationship with Kelly. Kelly regularly punished Jane Doe number 18 in various ways when she violated.
Hold on. I want to address his lordship. He says that after reading that, you're still going to flip that. Now, here's what I'm going to tell you. There was no police report. There is no rape kit done. There's no charges ever charged by these individuals. They did not go to the police to press charges. That in itself is something to be said.
15 said she went to the doctors after 3 years and wanted a settlement.
3 years. 3 years.
After 3 years of a sexual relationship.
Let me explain something to you guys. I know everybody do things totally different and how they do it, but majority of the time when you're doing it that way, it's always about money. It's always about money. It's always a money grab. It's always a money grab. Because if somebody violates you in a way, you're going to run to the police. You're going to tell somebody about this situation.
You're going to tell somebody.
Yeah, you're going to go and try to get some sort of remedy for your pain.
I mean, and when there's this many bad acts, you would think that one of the bad acts, maybe two of the bad acts, would have filed a claim. They didn't file claims. They wanted lawsuit. I mean, money.
And
all of them.
Where's the video that they keep claiming that was shown? Where's the videos? Yeah, we're gonna read some more stuff for you. We got a lot of stuff that was done.
And I mean, also think about the fact, like, there is one person in her testimony who said, when I said I didn't want to do something, he said, that's okay, go to the next room. You know, like, people had a choice. They chose to go along if in fact any of this happened.
But this was, anybody ever heard, because I played the whole, like, that sexual, I don't want to say the word. Oh, I've said the word. I didn't want to say the word. But having that type of lifestyle. You know, a lot of celebrities, a lot of entertainers, a lot of people with money have that outrageous lifestyle. Wife swipe, wife swap.
H&M? Is it called H&M?
Yeah, H&M, BDSM, whatever that thing is, whatever that thing is. They have strange lifestyle. It's not illegal. It's just strange. A lot of us don't do it. It might be immorally wrong.
As a matter of fact, someone said the other day, who would pee on people and who would allow something like this? And I said, well, first off, if a woman allows for you to do that and they don't get up and run and scream, obviously it wasn't a problem for them and with them. And people have selective outrage. Mind your business, because what someone does in their bedroom is their business. But he also wasn't convicted or proven to have done that.
But listen to this. Remember I told you guys I used to do that voice actress thing? There was a lot of weird stuff that people would want me to talk to them about doing to them.
I personally myself know somebody who was paid to let somebody touch her feet. That sounds crazy, but he just wanted to play with her feet.
Even fecal matter. There's people that do that. That's just like, it's not my cup of tea, but there are people out there who have some outrageous fantasies and lifestyle like that.
Do you guys remember Biggie Small's song where he said the heifer wanted him to poo-poo on her? And he was like, what? And then he said, and after I poo-pooed on the girl. It was, it was the intro to his song, but I know people remember hearing that.
I mean, certain things it's just like outrageous, but but listen, that's their bedroom. That's the way I look at it. Not exactly. Mine. That's their bedroom. And there are people who missionaries all they care about. You know what I mean? And some folks be like, okay, this person is really boring, but there are some people who do outrageous stuff.
Yes, nasty girls, T-girl. Yes. Okay, I'm gonna jump back in. Where am I? Jane Doe number identity. Approached Jane Doe, wanted to meet her. Okay, so we're on Jane Doe number 18. Is 18 Hallie? 18?
I think so.
Let's see. Jane Doe number 18, whose identity is known to the government, met Kelly at one of his concerts when she was approximately 20 years old after one of Kelly's associates approached her and told her Jane Doe number.
Hallie was 19 when she met him. This one here is 20.
Okay. And Kelly that wanted to meet her in or about 2016. Jane Doe number 18 started a sexual relationship with Kelly. Kelly regularly punished Jane Doe number 18 in various ways when she violated his rules. For example, Kelly violently spanked, hit, and kicked Jane Doe number 18 on multiple occasions. At times, Kelly also instructed Jane Doe number 18 to text Kelly that she liked being spanked after administering the spanking as punishment. In addition to the spanking, Kelly ordered Jane Doe number 18 to walk back and forth in heels.
That is her. That is Hallie.
For a long stretch of time, repeating as she walked what he deemed she had done wrong as punishment. At a concert in November 2017, Kelly became enraged with Jane Doe number 18 because he suspected that she had been communicating with another man and grabbed Jane Doe.
Hold on. Hey, y'all, try not to put that word inside the text, please. Dolores, try not to put that word inside the text.
Put a 3 in the middle of it instead of an E.
Yeah, put a 3 instead of an E. Go ahead, sorry.
Okay. Oh, okay. So because he suspected that she had been communicating with another man and grabbed Jane Doe number 18 and broke her necklace, cutting her neck. I believe she spoke on this in either Surviving R. Kelly or in an interview.
Hold on a second, 1 second. The text messages, not every text message was shown. Not every text message was shown. Certain ones did not. They didn't have text messages from a long time ago. They only had text message from Jane Doe number 5, which is Azriel. They had text message from Azriel.
But in this story, for Holly in Surviving R. Kelly, I believe she said every couple has little spats. He didn't fight her. He just grabbed her necklace and it scratched her. So I believe that's how it was put in Surviving R. Kelly when it came out of her mouth. But in this paperwork, it looks more heinous. Kelly then made her go back to the hotel room where she was staying and write a note stating that she had attacked Kelly. Kelly dictated to her what he wanted her to write in the note. When she finished the note, Kelly directed Jane Doe number 18 to give him the note for his future uses. On other occasions, Kelly slapped Jane Doe number 18 because he believed she was looking at or talking to other men in violation of his rules. In addition, during their relationship, Jane Doe number 18 signed a non-disclosure agreement and at Kelly's direction wrote letters in which she wrote embarrassing falsehoods and witnessed others write similar letters. The government recovered various letters written by Jane Doe number 18, including certain ones that contained certain falsehoods, which were dictated to her by Kelly, so that he could use the letters against her at a later date. None of these letters were presented.
Hey guys, have you ever seen the movie 50 Grades of Shade? 50 Grades, Colors of Gray, whatever.
50 Shades of Gray.
Gray. Do you remember Christian? This is nothing but that movie. I'm telling y'all, there's nothing but that movie.
None of these letters were not her letters. Her letters weren't presented. So if they had them, they didn't present any.
The twins' letters was presented. Well, the text message between the only person that you got information from was Azriel. Because remember, Azriel, when the whole thing was, remember that she had the stuff in the clouds and people, her family was getting that it's all part of that whole setup. Her stuff, you know.
We should let them hear Azriel's letter when we get we're not doing her, huh?
No, we're not.
But if ever, they should hear Azriel's letter.
I did play it the other day. I did play it.
Oh, okay. Well, then go back and watch, you guys, if you didn't see it. I obviously didn't. I'm sorry. Okay. Because he believed she was talking to another man. Kelly also directed Jane Doe number 18 to make recordings of herself engaged in compromising and disparaging acts and making certain statements at his instruction, and to provide those recordings to him. The contents of those recordings, which would cause Jane Doe number 18 embarrassment and reputational harm if disseminated to others, were thus available to Kelly's use at a time of his choosing. At Kelly's direction, Jane Doe number 18 also engaged in sex with Kelly and others, including Jane Doe number 5 and Jane Doe number 2, an individual otherwise unknown to her, which Kelly regularly reported. In or about the fall of 2018, continuing through January 2020, Kelly and other members of the enterprise, including Don Russell, towards number 6. You know what? I'm going to skip this one because it goes back to number 6 and we're only doing uncharged. So hold on, let me see if we have anything else. Number 6. Oh yeah, so one thing to say about 18, Jane Doe number 18, is she left and came back 12 times. She had her own apartment. And so, yeah, she wasn't held captive. She had boyfriends during their time together. And again, she left and came back 12 times. When she said she wanted to leave, she did, and he paid her flights.
Okay, listen to this. I've been saying that in Oklahoma, they're trying to change the law. Any STD, you can be charged if someone is aware that they have contacted the STD and gave it to someone else without letting them know. Go ahead. I'm sorry.
Okay, so now I'm to 19. In or about November 2018, Kelly summoned Jane Doe number 19, a former girlfriend of Kelly, and whose identity is known to the government, to travel interstate to Chicago, Illinois. Once in Chicago, Kelly made Jane Doe number 19 provide her driver's license to an assistant to photocopy and sign a non-disclosure agreement. Kelly also told Jane Doe number 19 that she needed to decide which team she was on, Team Kells or the other one, and that she had a beautiful family and she did not want to be handled. A comment that Jane Doe 19 construed as a threat. Finally, during that encounter, Kelly and Jane Doe number 19 write a text message to Kelly containing falsehoods. I must have missed some of 19. But I don't see it in here. That's all it says for 19 right now. Let's see. Right. Then it goes to the bribery. Let me keep scrolling down. Kelly's efforts to obtain, no. I apologize. I have to scroll through the paperwork because it's jumping around with other things.
Just go ahead and read. Let me just go ahead and get the rest of this other stuff ready for you.
Okay.
Where are
Similarly,
you reading that perspective? Let me see where you are. I'm just
so right now I'm scrolling down. I am on page 33. I'm just trying to figure out where there's other information about the Jane Does after number 6.
Okay, I'll keep looking.
Okay.
Okay, go ahead.
Similarly, 16. Okay. What does this one say? Analysis. First, as described below, each of the above described uncharged acts are integral in providing the existence and nature of the enterprise charged in this case. Specifically, such evidence is admissible as proof of inter alia. I don't know if I'm saying that right. ALIA. The activities, purpose, and means of the enterprise, the defendant's role in the enterprise, and the proof that the alleged predicate racketeering acts constitute a pattern of racketeering activity. The other acts evidence the government seeks to admit: Kelly's sexual abuse of minors, Kelly's use of a physical harm and threats of physical harm on his victims, and the unlawful imprisonment of women. The use of extortionate and coercive tactics to extort and maintain control over his victims and employees, and bribery. All are evidence of the existence of an enterprise. It proposes means and methods, the patterns in racketeering, and specifically the relatedness of the racketeering acts and the threats of their continuity. For example, Kelly's abuse of Jane Doe 7, 8, 9, Jane Doe 10, 13, and John Doe 1, all minors at the time the abuse and attempted abuse began, is evidence that his abuse of the other ones is a pattern. Kelly's direction, no, I'm not going to read that. Demonstrates Kelly's motive and intent with respect to the charges, minor victims, Jane Doe number 7, Jane Doe number 8, Jane Doe number 9, 10, 13, and John Doe 1. Let's see. Tactics to unlawfully imprison women and girls to ensure their availability for Kelly at Kelly's demand are evidence of the enterprise itself and its means and methods. Similarly, Kelly's physical and psychological abuse of Jane Doe number 16 and 17 and 18, and Jane Doe 20, and threats towards employee 1 and Jane Doe number 19 and 20 all tend to show that the similar abuse of Jane Doe, the other Jane Does, is a pattern. Scrolling down, scrolling down, scrolling down. Do you see anything or a place I should start, Tanya? Kelly and members of his inner circle negotiated financial settlements with multiple women and girls, including Jane Doe number 10, 11, 12, and Jane Doe number 15, in exchange for their silence, thereby helping to ensure and continue existence of the enterprise. Finally, evidence of the discussion between the defendant and the crisis manager regarding bribery is probative of the required continuity components and tends to show the horizontal relatedness of the bribery charge in the Racketeering Act of number 1.
Which page are you on?
Now, this is 34, and I am at it. I think it says number 2, certain evidence of other acts.
34.
For the following reasons, do you want to do it?
Let's see. I'm trying to find it. So are we 34 on the page or 34?
34 on the page and about two paragraphs up.
Okay, so it says the following reasons. Are you starting right there?
Yes.
Okay, where it says certain evidence of other acts is directly relevant to and excruciability intertwined with the evidence of the charged crimes. For the following reasons, certain evidence of other acts is also direct evidence of an intricable intertwined with the evidence of the charged offense and thus admissible to complete the story of the charged crimes. A legal standard. It is well settled that evidence of uncharged criminal activities is not considered other crimes evidence under Federal Rule Evidence 404B if it arose out of the same transaction or series of transactions as the charged offense. If it is extricable, intertwined with the evidence regarding the charged offense, or if it's necessary to complete the story of the crime on trial, and it gives some cases to refer back to. And then it says the Second Circuit has repeatedly upheld the admission of uncharged act evidence as direct evidence of the charged crimes where such evidence provides necessary background or content for the charged crimes. And it says see United States versus Gonzalez. Uncharged burglary admissible in trial for felony and possession of firearm because inter alia, it provided critical background evidence that gave coherence to the basic subsequence of the evidence that occurred on the night of the defendant's arrest. And it's just talking about that. So noting that the evidence of other bad acts may be admitted to provide the jury with the complete story of the crimes charged by demonstrating the content of certain events relevant to the charged offense. Do you think that's what they're doing? I don't know. Let me read that again. Noting that evidence of other bad acts may be admitted to provide the jury with the complete story of the crimes charged by demonstrating the context of the certain events relevant to the charged offense. And it gives another case law. It is within the court's discretion to admit evidence of acts committed prior to the time charged in the indictment to prove the existence of the alleged conspiracy as well as to show its background and history. Prior acts evidence may be admitted to inform the jury of the background of the conspiracy charged, to complete the story of the crimes charged, and to help explain to the jury how the legal relationship between participants in the crime developed. In this respect, trial courts may admit evidence that does not directly establish an element of the offense charged in order to provide background for the events alleged in the indictment. Background evidence may be admitted to show, for example, the circumstances surrounding the events or to furnish an explanation of the understanding or intent with which certain acts were performed. B is the analysis. Evidence of certain of the other acts described above are so intrusive. I can't see them with my glasses. So what is that word, guys? Okay, intertwined that they are necessary to complete the story of the crime on trial, and it's got a case law. First, evidence regarding Kelly's illegal sexual relationship with Jane Doe number 1, a minor he believed he had impregnated, is necessary to establish his motive, intent, and plan, among other things, for engaging in the bribery conduct charged in Racketeering Act 1. Jane Doe number 9's testimony that she advised Kelly that she had contracted herpes from Kelly, and Jane Doe number 11 and Jane Doe number 12's lawsuit against Kelly as a result of their contention that he exposed them to herpes, all constitute evidence of Kelly's knowledge that he had herpes, an incurable sexual transmitted disease, and could transmit it to others. Both the elements that the government will need to prove at trial to establish Racketeering Acts 8, 12, 14, and counts 6 through 8. Additionally, Jane Doe number 5 heard and saw Kelly inflict physical assaults on Jane Doe 16 and 17 and 18, and evidence of such assaults therefore helps to explain in part how the defendant maintained control over Jane Doe number 5. Similarly, Kelly and other enterprise members' efforts to threaten Jane Doe number 6 and her mother with the exposure of embarrassing photos of her in evidence is evidence of Kelly's regular recording of his interactions with Jane Doe number 6, as she will testify, and is part of Kelly's attempts at maintaining control over Jane Doe number 6, as well as the existence of the enterprise and the links to which Kelly and other enterprise members went to protect the enterprise. Kelly's threats toward employee number 1 also helped to explain her evolving relationship with Kelly and how Kelly maintained control over enterprise members. Limited evidence regarding the existence of Kelly's prior Cook County criminal case, the nature of the charged crime, sexual exploitation of a minor, the case's duration, approximately 6 years, and his ultimate acquittal after trial is also intertwined with evidence of the charges, crimes, and evidence regarding the existence and evolving means and methods of the enterprise. For example, the government expects that certain witnesses will testify about changes in the protocol used by certain employees in an effort to protect the enterprise following the initiation of the prior crime case and during the lengthy presidency. It is also intertwined with Kelly and other members of the enterprise use of certain methods, including the collection of identification documents and the use of non-disclosure agreements and settlement agreements, as well as threats, coercion, and extortion to prevent women and girls from reporting his conduct to law enforcement authorities. Additionally, evidence related to the facts underlying the charge include the fact that a video of the defendant engaging in sexual activity with a minor was widely and publicly disseminated, is relevant to the defendant's knowledge and intent with respect to the charged crimes, to show that the defendant understood the consequences of his actions when he filmed underage girls, including Jane Doe 4 and 5, i.e., that such videos could be disseminated, and that his purpose of having sex with these minor victims was, at least in part, for the purpose of producing such a visual depiction and not by accident or mistake. In addition, the nature of the charges is relevant background to explaining why the defendants told many of his victims that he would be giving certain items, including some of the letters containing falsehoods, to his lawyers for safekeeping. The fact that the charges is also relevant background to explain why Jane Doe number 1 told the defendant that he had access to a jury. John Doe number 1 that he told the defendant that he had access to a jury, a fact that the government should be permitted to affront by eliciting on direct examination rather than waiting for the defendant to elicit as impeachment material on cross-examination. The nature of these charges and the fact that the defendant acquittal are also necessary background to explain why many victims of his abuse initially failed to report to law enforcement the abuse. A failure to report is a common theme among victims of sexual and domestic abuse, and particularly so in scenarios as here, where the abuser, the defendant, is a prominent public figure with an active fan base. Indeed, a victim's failure to report will likely be raised by the defendant during cross-examination in support of an argument that the victim's testimony with respect to Kelly's conduct is fabricated. But the failure to report and instead seek a civil settlement or simply to remain silent is readily explained by the fact that the defendant was once charged with sexual exploiting a minor. There was a video widely believed to feature the defendant with a minor, and the jury acquitted him. Thus, the 2008 charges and the acquittal are necessary background to help explain why some of his victims long opted against reporting his Did you hear that? Wow.
Read that part again. Read that part again.
Okay, so a victim's failure to report will likely be raised by the defendant during cross-examination in support of an argument that the victim's testimony with respect to Kelly's conduct is fabricated. But the failure to report and instead seek a civil settlement or simply to remain silent is readily explained by the fact that the defendant was once charged with sexually exploiting a minor. There was a video widely believed to feature the defendant with a minor, and the jury acquitted him. Thus, the 2008 charges and the acquittal are necessary background to help explain why some of his victims long opted against reporting his conduct.
You see that?
Nor is the
That's basically saying that the jurors got it wrong. So you're saying that the justice was not served with those jurors. So you basically trying to super serve.
Well, they're basically saying that in 2008 in Chicago they got it wrong. He in fact did what they said he did, but they acquitted him on it. So because he got away with 2008,
yeah,
he goes. So because of what happened in 2008, they can't trust the fact that it won't happen again to them, which is crazy.
So that makes it prejudice then.
So how did most of the victims that they're saying supposedly didn't even know about it?
Mm-hmm. Wow. Okay, go ahead. But it's just like we're gonna get you any kind of way we can. If it means cheating and lying and getting people to buy in, we got you. And this is what happened because they lied on the witness stand. We're gonna show you where they even talk about the inconsistency. Guys, get the troll, please. Get the troll because there's a lot of them in here today. It's like whenever I'm talking about stuff like this, you notice they come in here a lot. The trolls. Donnie, go ahead. I'm sorry.
Hold on. Let me see where I'm at. One second. My page just completely. I was having computer issues this morning, Sylvia. I'm sorry. Perspective, are you there for a second? I don't know what just happened.
I am here, but let me see if I can see exactly where you are. Pitt County case introduced.
My bad.
No, it's okay. I went to get some crackers, so it's my fault. I haven't eaten this morning.
I think I was on page 39.
Okay.
I'm restarting my computer.
The Second Circuit has established non-test. Second trial must determine the evidence. I'm trying to find exactly what you just read about them speaking about the 2008 case, and I am not seeing that. Okay, let me go back up.
It's on page 38, I think. The bottom of 37 or page 38.
Okay. I don't see any mentions of 2008 on 37 or 38. My opinion of how I interpreted that was they're saying that those girls were essentially discouraged from speaking up because he got away in the 2008 case. And there it is. I found that. Okay, so in the alternative, the government seeks to admit evidence of the other acts described above and pursuant to Federal Rule of Evidence 404B. Evidence of uncharged crimes or other acts may also be admitted pursuant to 404B for permissible purposes, including to prove motive, opportunity, intent, preparation, plan, knowledge, identity, and absence of mistake of accident. Evidence is only admissible if, under Rule 403, the probative value of the evidence is not substantially overweighed by the danger of unfair prejudice or by consideration of judicial economy, such as the needless presentation of cumulative evidence, which obviously they did.
Look at this. Hold on, y'all. Listen to what the government. Think about what you just said. Perspective me. You said that they were afraid of him not being found, whatever. But you go on Surviving R. Kelly and tell your story.
Right.
That doesn't make sense.
And that was only because they were offered money and fame. Because after that, they went on award shows. They did book signings. They did interviews. So
and here's the deal: the book, supposedly the book, Javante, whoever she was, what happened to her book? Why didn't she write a book way back then to tell her story?
Well, again, Javante was claiming that she had not slept with him. She said, didn't she say something like she didn't fall for it, or?
Yeah, she said she never slept with him.
Okay. The Second Circuit has established a three-pronged test for the admission of other crimes evidence under 404B. First, a trial court must determine that the evidence is offered for a purpose other than to prove the defendant's bad character or criminal propensity. Second, the trial court must determine that the evidence is relevant under Rules 401 and 402 of the Federal Rules of Evidence, and that it probative value is substantially overweighed by the danger of unfair prejudice. Third, the court must provide an appropriate limiting instruction to the jury if one is requested. So I wonder how the judge determined that all of this was not substantially overweighed.
Well, we're going to read what the judge ruling, the one I sent you for November, dated November 4th. We're going to read that one.
Okay.
It's going to explain some stuff, and there's been some like overreaching, and so now they try to justify why they did certain things because not good whatsoever.
Okay, so while the government must explain in detail the purpose for which the evidence is sought to be admitted, the Second Circuit has emphasized that the Federal Rule of Evidence 404B is a rule of broad reach and liberal application. We have adapted exclusionary or positive approach to 404B. As long as the evidence is not offered to prove propensity, it is admissible. Can someone look up the definition of propensity?
Somebody look it up, spell it for them.
Propensity. I'm not sure what propensity is.
Propensity.
SITY.
Look up that word for me, somebody. Look, yeah, I know y'all was gonna do some homework when you're getting in this and when you got inside this chat, so don't play me.
Propensity.
Yeah, y'all know y'all was gonna do some homework, okay? Let's not play games. Look, the numbers are going down now. Basically, a tendency.
A tendency. Okay, so I'm gonna read that sentence. As long as the evidence is not offered to prove propensity, it is admissible. But I thought that's what they were proving, a tendency. Okay. To the extent that the evidence of the uncharged crime is offered to prove knowledge or intent, the law requires that the other act and the charged conduct be sufficiently similar to the conduct at issue to permit the jury reasonably to draw from the act the knowledge.
Here's the thing that bothers me about this. All of this was never proven. Never proven, never charged. No, nothing was ever done.
Yeah. Okay, I'm just gonna go further down. Finally, additional basis for admitting other acts evidence under Rule 404 include corroborating crucial prosecution testimony. If the corroboration is, sorry about that. A car is starting outside. Corroboration is direct and the matter corroborated is significant. And where cross-examination into a government witness bad acts for impeachment proposes is anticipated, allowing the government to elicit the witness's testimony about such acts on direct examination so as to avoid the appearance that the government is concealing such purported impeachment evidence from the jury.
Okay. Now, are you finished? Because what I wanted to do is bring in, remember the part where the judge was her allowance, and then we're going to talk about the part where that young lady was not there when the video was played. She was sick or supposedly sick, and they still played the video anyway, and she did not testify. So let's talk about that. Let's go into that paperwork on that.
Okay.
So she didn't testify. Remember, is she the one that said she was so sick and when she's stressed out?
Yeah, and they played her video anyway, but she did not testify at all. So go to the judge ruling. And we're gonna go to okay, let's go to the discussion part, which is page number 5.
Did you send that to me?
Yes, I sent everything to you.
Okay.
It says judge ruling. It's dated 11/4.
Okay, Sylvia, I am with Tanya. I got 4 things. Do we have 4 things?
Yeah, I don't have it.
Let me resend it to y'all. Y'all not getting stuff. Hold on.
You said, did we get the email? We got the email.
But we don't have that part.
Hold on. Hold your horses, young lady. I'm withholding evidence from y'all, huh?
So based on what we just read, what conclusion would you guys come to as our juries? You're the jury. That was a lot to lay on, right?
Yeah, that was a lot. That's what I was getting ready to ask. So what would everyone's opinion be about so far? Do you feel that what we just read about uncharged and all of that was actually the case?
I mean, we could see how his lordship seen it.
Well, let me tell you, the young lady who works in the court system says that she said not enough receipt for her.
Yeah, they spoke a lot about having things that were not shown. And I know a lot of times some things are not allowed in. But you would think if she allowed this testimony that she would allow the proof of the testimony.
Yeah.
But she did not, or it was not there.
Check your email. Check your email, Yana.
Going.
Go down to page of number 5.
305.
Page, huh?
What page?
Page, I think 5.
5. Okay. Okay. Discussion.
Cecilia,
Request.
check your potato, couch potato. Check your email. I love calling her couch potato.
She want to come up and read?
Couch potato, come on in. Couch potato. Couch potato, come on in.
Sylvia, are we at discussion? Request to admit certain evidence?
No, we're at judge ruling.
Judge ruling. So that's not 5. Let's see.
Just check your email. No, she's not coming in. I was just telling her to check her email. Where'd Tanya go? Did you see judge ruling?
That's probably what I'm on, but I'm trying to see. You said page 5, and at the beginning of page 5, the title was discussion.
Yeah. I'm sorry. My bad.
Okay.
I'm like, I thought you were talking about, okay, we're going to have a discussion.
No. Okay. You want me to start there?
Yeah, where are we starting at? I'm sorry.
She said page 5. So right under page 4 where it says discussion.
Discussion.
Page 4.
Page 5.
Page 5. Discussion. Request to admit certain evidence, right?
Yes.
All right, cool. A, sexual contact with Jane Doe number 1, a minor in 1994.
Now listen to why they allowed it to come in now. Listen, guys.
Okay. The government moved to admit evidence that the defendant had sexual contact with Jane Doe number 1 in 1994 when she was a minor. The motion was granted. In Racketeering Act 1, the defendant was charged with bribing a public employee. According to the government, the defendant and his associates bribed a public official so that the defendant could marry Jane Doe number 1 as a part of an effort to conceal the fact that she had sexual contact with her when she was 15. Evidence of the defendant's sexual contact with Jane Doe number 1 was say that word for me.
Ooh.
Yeah, I know. Intertwined with the evidence of the bribery and establish the motive. The evidence was therefore relevant and not barred by Rule 404B, nor was it barred.
Hold on. Let's back it up a minute. We're going to take our time with this, y'all. We're going to do a little series. We're going to take our time with this. Now, read that slowly again, Tanya.
And I'm skipping that word. So
Inextricably.
Yeah.
Inextricably.
Spell
Yeah.
Spell it so they could figure out what that word. What?
I-N.
Hold on.
INEXTRICABLY.
I think it's a ton in
Hey, y'all. Hey, my scholars, can we get a definition of that one?
Inextricably.
Inextricably. Okay, yeah, there you go. When I get to that, you say it because I'm tongue-tied on it. In Act 1, the defendant was charged with bribing a public employee. According to the government, the defendant and his associate bribed a public official so that the defendant could marry Jane Doe number 1 as part of an effort to conceal the fact that he had sexual contact with her when she was 15.
So what was the proof for that?
Huh?
What was the proof of that?
There was no
proof. It was just
hearsay.
one person's word.
Exactly. Hearsay, right? Okay.
Okay, but we can play videos where she said she didn't. They were
Yeah.
just friends. Anyway,
Let's,
evidence of the defendant's sexual contact.
Trees, we're not looking how to pronounce it. We're looking at what it means. That's why.
Well, I can look at to pronounce it is what I'm trying to do. Okay, the evidence of the defendant's sexual.
Tree said you can go to Google and they'll pronounce it well.
But we're reading right now.
Evidence of the defendant's sexual contact with Jane Doe number 1 was
Inextricably
intertwined with the evidence of the bribery and established the motive for it. The evidence was therefore relevant and not barred by Rule 404B. Did we hear that?
No, it's not barred by Rule 404B. So that means that
That's prior bad acts. 404B, that's what that means, right?
okay, yeah. So it's not falling under the umbrella of
Prior bad acts.
prior bad acts.
So why not?
It's not being barred because of the prior bad acts rules.
Mm-hmm. What is Rule 403?
Go check your email. Oh, she said
I don't remember. I read it 50 times, but I wasn't reading to keep it.
Let me see real quick while we're waiting on somebody else to come in. Okay. Rule 404.
404 was the bad acts. What is 403?
Okay, 403. Okay, 403 says, Rule 403 is a balancing test of the probatable value of evidence against the harm likely to result from its admission into court. For example, gruesome photographs in a murder case are not usually considered prejudicial as they show the victim's injuries, the crime scene, and the blood spatter. So, interesting.
So this is not prejudicial because it shows like prior act.
Mm-hmm. Yeah. Okay. It says, nor is it barred by Rule 403. It was relevant and probative for the reasons just discussed and was no more inflammatory than the charged offenses. Evidence shall be excluded as unfairly prejudiced when it is more inflammatory than the charged crime. B. Jane Doe sexual contact with Jane Doe number 7, a minor in 1991. The government moved to admit that the defendant had sexual contact with Jane Doe number 7 when she was a minor, and that Jane Doe number 7 observed the defendant having sexual contact with Jane Doe number 1. We know who Jane Doe number 7 is. Let's call him out.
Javante.
But here's the deal. Javante says contradiction statements on her
podcast,
her show with
but again, why did the government allow this to be admitted when he was not charged with having sexual contact with her?
With Aaliyah or her? Yep.
Especially number 7. Number 7, he wasn't charged with having sex with Javante.
Neither was he charged with Aaliyah either. He was charged with bribery.
Bribery, yeah. So why did we taint the jury by telling them that he did?
And you guys have to remember that number 7 was not allowed initially. The judge kept saying no to number 7, and then last minute decided to say okay.
Yeah.
Yeah, because she was not allowed. But because they were losing so bad, they begged for her to be able to come in because Demetrius basically wasn't testifying to the tying Robert to the bribery.
He was throwing it off. Remember, Demetrius really went in there and they were like, wait a minute, he's not as credible as we wanted him to be, and let's go because he's playing games, remember?
Mm-hmm. Exactly. And so as a result of that, they begged for number 7 to be allowed.
Okay.
And she allowed it after she had already ruled that she wouldn't.
Okay. So, so when she was a minor, and that Jane Doe number 7 observed a defendant having sexual contact with Jane Doe number 1. In supplemental briefings on this request, the defendant argued that the evidence was needlessly cumulative. On August 18th of 2021, before opening arguments, I granted the request in part and denied the request in part. I found that evidence that Jane Doe number 7 witnessed sexual contact between the defendant and Jane Doe number 1 was admissible for the same reasons that evidence of the defendant's sexual contact with Jane Doe number 1 was admissible. But none of this was proven. Like, it's hard for me to read this because.
But he was never charged. It was never charged
know.
in that one.
She's saying she allowed it because it was it was going to, it was fitting in with everything else that she was allowing in, but none of it was proven. Just because a person said it didn't make it proven. There was nothing behind it that was evidentiary. There was no
pictures, no videos, no nothing.
Exactly. Like, as far as Aaliyah being pregnant, there was no doctor's report. There was no abortion. There was nothing corroborating this one person's story.
But we told that to the jury, though. Do you understand? We told them that.
If you listen to the testimony of the worker of the, they said they never gave it to them. And Daryl McDavid the next day went and got something. That's what was told in court. Do you understand what I'm saying? Because the lady said they didn't give it to him because they didn't have the documents for it.
Yeah. It
came back the next day.
Okay.
We gotta go like through the fine cone of this stuff,
Well, see, and I'm sure if we're kind of like puzzled by all of this, and we don't know the law, but we're just using common sense, like R. Kelly told us, and like Judge Donnelly said, use your common sense on stuff. This doesn't, just in my common sense, not because I'm a supporter of Mr. Kelly, but because this just doesn't make any sense. And so if we're going back to say we are uncharged acts, so why are we telling the jury that he had sex with Aaliyah, she was pregnant, if we have no proof of that?
And she cannot speak up for herself because she is deceased.
Even though they charged and the judge may give them instructions to forget, like we're going back to what we said earlier, you can't unhear stuff.
Okay, look,
right?
Look. This is couch. She says Jane Doe number 1 is deceased. What in the world? That definitely should not have been admitted. Wow, I'm feeling that this judge is admitting.
That's what I'm saying. Why did she allow that conversation to even come up? So let's talk about what the conversation should have been. Okay, so if we're talking, let the bribery, don't nobody else say nothing about she was pregnant, this or that. I know they spoke about her being pregnant to prove why he married her, but it's just.
But there was no
evidence, and she's deceased. Why are we talking about a deceased person?
And my thing is, why didn't I know the judge didn't allow a lot of things in, right? Why didn't well, they wouldn't. Okay.
Well, they needed this bribery charge to basically help them get the Rico.
Yes, they needed that.
Because they needed 3 charges, right?
Yes.
They needed Mann Act. They needed
they need at least 2 out of the 3. That's what it was said. 2 out of the 3.
2 out of the.
One part of this one, which is bribery, and then the other part.
That the Purple Couch is saying there was no testimony of her saying, they didn't have no video, no medical records or anything that she was pregnant or that they ever was intimate. Every video that Aaliyah has even spoke of, I would have, if I was the defense, would have played. We never had a relation. Why was that not brought in? Why?
And listen, also with the marriage thing, they didn't consummate the marriage because he left the same night right after they got married.
But so why wouldn't the defense be able to play a video of something of her saying, he's a really good friend? People have asked her, were you guys married? Blah, blah, blah. No.
Even the mother. Why couldn't they play the mother's letter?
Why didn't they bring the mother in?
Why didn't they subpoena her? Anyway, I'll go back. So on August 18th of 2021, before opening arguments, okay, I already read that part, right? Because it took place before. No, I haven't. On August 18th of 2021, before opening arguments, I granted the request in part and denied the request in
Yeah, you
part.
did read that.
Okay. I found,
Right on
okay, so on
September 4th.
September,
Yeah,
okay,
can
on
you
Sep-
give me a moment? I want to go ahead and go look up the lady, the person from the the ID person. Go ahead and read. I'm just gonna go look up. Go get
Yeah.
that for you guys.
Yeah. T-Girl, the defense wanted to play. Yeah, I know, but I'm saying, I know they did, but I'm like, why wouldn't the judge be fair? Like,
it was unfair. Yeah.
On September 4th of 2021, the government renewed its request to admit evidence of the defendant's sexual contact with Jane Doe number 7, arguing that it was, there you go.
Oh, I'm sorry. Inextricable. That's what it is. Okay.
Inextricably intertwined with the evidence evidence the court had ruled admissible, and made an additional proffer that when the defendant had sexual contact with Jane Doe number 7 and other minors, his associates knew what the defendant was doing. The defendant opposed. On September 9th, I granted the government's request. So she denied it on the 4th.
No, she denied it before the 4th. The 4th is when they put it back in. She denied it August.
Yeah, she denied it originally. And then I guess when they saw Demetrius wasn't doing too well, they asked for it again, and that's why it came in.
On September 9th, I granted the government's request. The government's additional proffer made clear that the evidence was inextricably intertwined with Jane Doe number 7's account of witnessing sexual contact between the defendant and Jane Doe number 1, and was additionally relevant evidence of the enterprise's means and methods.
So how do you go from denying it, and then they had a witness that was no good, then all of a sudden now you approve it? That is not fair.
And how is that fair to the defense when they did not have to fight?
I didn't have time to prepare for that.
Yeah. They did not have to fight against that because it was denied. Then all of a sudden you are allowing it.
That's not fair.
And again, Kanik only had about a month or two to even look over this paperwork. She was denied, so she was not something he had to worry about.
They didn't even let Kanik get more time either. That was not fair.
Jane Doe number 16 was Haley. Okay, all right, we're finished. Okay.
No, she's 18.
Okay.
She's 18.
Okay. She said on September 9th, I granted the government's request. The government additional proffer made clear. Okay.
Going down.
Okay, let's go down. According to the evidence, was neither unduly prejudiced nor cumulative. Sexual contact with Jane Doe number 8. The government moved to admit evidence that the defendant had sexual contact with Jane Doe number 8 in 94 when she was a minor. Specifically, the government sought to present evidence that Jane Doe number 8 was at the defendant's concert, and that one of the defendant's associates directed her backstage where she had sexual contact with the defendant. What? Was granted.
Request was granted.
Wow. This evidence was direct evidence of the enterprise and its means and methods to establish an association, in fact, enterprise within the meaning of.
So where's the evidence, since they are not presenting this enterprise member who gave her this pass to go anywhere?
Exactly. What evidence do you have?
What evidence do you have besides that this person said this?
Y'all, I haven't seen any evidence except word of mouth.
This evidence was direct evidence of the enterprise and its means and methods to establish an association, in fact, enterprise within the meaning of 18 U.S.C. Blah, blah. The government was required to prove beyond a reasonable doubt, among other things, a purpose and relationships among those associated with the enterprise. The indictment charged that the defendant was.
Okay, hold y'all. I got.
Wait a minute, that's me.
I got something to say. Hold on. All right, you ready? It says here that is what
Wow.
publicly does not appear that the judge has had a lot of criminal reversal. But you want me to say that publicly?
Yeah, it's published publicly, so you can say that part.
Okay. But again, from the criminal case that was affirmed, it was not a complicated case such as R. Kelly. And with her own concern about his counsel, there may be a glimmer of hope that at least he may get another trial. All right now.
Well, you guys have to remember that she just became a federal judge, right? She hasn't tried very many cases since she's been appointed.
Yeah, she's been there for 7 years.
When
Can you
Obama.
read that again, Rosalia? One more time.
All right. Go ahead, read it, couch potato.
Okay. All right. Basically, it is published publicly, so this can be said that it does not appear that the judge has had a lot of criminal reversals. But then again, from the criminal case that was affirmed by the appeals court, it was not a complicated case such as R. Kelly's. So with her own concerns about his counsel, there may be a glimmer of hope that at least he may get another trial. Not sure about a complete acquittal, but we will see what motion Jennifer files.
All right now.
Well, at least that is a glimmer of hope just based on that concern with the attorneys. But yeah, depending on what she files, there's going to be a lot of issues presented, I'm sure.
Mm-hmm. Yeah. For sure.
Welcome to the panel.
Mm-hmm. Thank you.
All right. Go ahead, you ladies. Go ahead on. Continue.
Girl, if you don't. Okay. I didn't read. Got me thrown. Okay. So was I? This request was granted.
You're at the indictment charge.
That's right. The indictment charged the defendant with leading an enterprise.
Hold on, yeah. Can we get the likes up? Guys, we're giving y'all some good detailed information. I know we're not showing it on the screen, but listen. I got to keep my stuff too, I paid for this. All right, go ahead. Sorry.
The indictment charged the defendant with leading an enterprise that included the defendant, his entourage, and others, and charged that the purpose of the enterprise was to recruit women and girls to engage in illegal sexual activity with the defendant, including by recruiting women and girls at concerts. Evidence of the defendant's encounter with Jane Doe number 8 was probative of the evidence of the enterprise and the way it operated. Thus, it was relevant and not barred by Rule 404B. Finally, this evidence was not unduly prejudiced. It was no more inflammatory than the charged offense and did not raise other Rule 403 concerns. Someone was going to say something? Okay. D, sexual contact with Jane Doe number 9, a minor, in 1995. The government moved to admit evidence that the defendant had sexual contact with Jane Doe number 9 in 1995 when she was a minor. In particular, the government sought to introduce evidence that the defendant began a sexual relationship with Jane Doe number 9 when she was 17 years old, that the defendant slapped her when she laughed at another man's joke, that she contracted herpes from the defendant, and that she told him that he had given her herpes. In supplemental briefings, the defendant argued that this evidence was needlessly cumulative. The request was granted in part and denied in part. Evidence that Jane Doe number 9 had a sexual relationship with the defendant in 1995, contracted herpes from him, and disclosed that she had herpes to him was admissible to show that the defendant knew he had herpes, which was charged in racketeering Acts 8, 12, 14, as well as counts 6 through 9. The evidence was therefore relevant. The evidence was not unduly prejudicial. It was not more sensational than the charged offenses, and it did not raise other 403 concerns. The evidence that the defendant slapped Jane Doe number 9 when she laughed at another man's joke, although relevant, was needlessly cumulative. Exposure of Jane Doe number 11 to a sexually transmitted disease in
I agree that was
2001.
cumulative. I'm sorry to interrupt, but like if they weren't going to present the witness, the man that she laughed at, to say, "Oh yeah, he did this," then it's still more hearsay.
Can I ask you,
Yeah.
what is the crime just to slap somebody? I'm just
You
sorry.
can't be slapping on folks.
Keep your hands to yourself.
You can't be slapping on people. Huh?
Wait. Since when it became a federal crime?
When they mound it all together.
Man, I see
Yeah.
people slap and just get a misdemeanor.
Mhm. So exposure to Jane Doe number 11 to a sexually transmitted disease in 2001, the government moved to admit evidence that the defendant had sexual contact with Jane Doe number 11 without disclosing that he had herpes. That Jane Doe number 11 told the defendant she believed she contracted herpes from him in 2001, and that Jane Doe number 11 entered a financial settlement with the defendant. In supplemental briefing on this request, the defendant argued that evidence of the settlement should be excluded because the jury would interpret it inappropriately as a concession of guilt, and because allowing the settlement agreement into evidence would send a chilling effect to any future settlements. Citing Rule 701C, which prohibits a lay witness from testifying based on scientific, technical, and or other specialized knowledge within the scope of Rule 702. The defendant also argued that Jane Doe number 11 should not be permitted to testify that she contracted herpes from the defendant. The government responded that the settlement agreement was admissible under Rule 408. The government request was granted. Evidence that Jane Doe
Asked for, they got. Everything the defense asked for, they didn't get. Wow.
Evidence that Jane Doe number,
even when she said no, she turned around and said yes.
yeah. Evidence that Jane Doe
and
number,
I guess we should point out that Judge Ann Donnelly came from a sex unit. That is the type of trials or cases that she tried as a what kind of attorney was she? As the kind of attorney that she was, that the kind of cases she did were sexually related. She defended
prosecutor. She was part of the prosecution.
Well, she defended people in sex crimes, right?
was she a defense attorney or was she a prosecutor?
Prosecutor.
A prosecutor, okay.
Remember the 5?
Yeah.
Manhattan 5, whatever. What was that? What was the name of those guys? Central
Park 5.
Yeah, thank you.
We was friends with that prosecutor.
Yes.
And she,
yeah, I believe she did her externship and everything in that type of office, and then that was her like specialized
kind of.
Yeah.
Wow.
I thought that was a conflict of interest when it came to certain kind of cases that she shouldn't be over.
What you all should do is read some of the Wall Street Journal. What I want to say, investigations into what's going on with conflict of interest.
Wall Street Journal. Okay.
Wall Street Journal.
Conflict of interest. Okay.
Well,
I'll finish this.
Not her in particular, but I'm just saying, what's going on in as far as the grip that they have on conflict of interest.
Okay. I will research that.
And as far as settlements go, they mentioned he wasn't signing the settlements. He had a power of attorney, right?
Yeah,
that's what I'm thinking.
Yeah. There was also talk of he didn't even know that these were going on.
Yeah.
Exactly.
Wow.
So while these settlements are leading people to believe he was just signing to hush people, He wasn't signing anything. His team was signing these things just to make people go away and
Boy.
give him his money, and he didn't even realize.
Right. Did they bring forth any of those, his team stating that they were the ones who actually initiated these
No.
settlements?
No,
No.
Wow.
No.
no.
Wow.
But they also brought none of the settlements into court except for one of the girls.
Which is Geronda.
It wasn't Geronda.
It's
It was
It was Geronda. I was there. It was Geronda. They talked about the case because they even talked about Bubba getting $4,000 out of it.
Mm.
I do
They even
remember
talked
that.
about her trying to give him money back.
Yeah.
Wow.
I remember all the mention of that, but when he asked everyone, "Do you have it here?" It was only one girl who had it, and it was the one who wanted to be back with him, and he didn't want her.
Yeah, but Geronda is the one they went and put it on the screen and showed. And they showed the amount that she got. $4,000 and all that stuff. They went into depth with hers.
Okay.
They also talked. Yeah.
Go ahead.
Okay, so evidence that Jane Doe number 11 told the defendant that she believed she contracted herpes from him was relevant. It was evidence that he knew he had herpes, which the government was required to establish beyond a reasonable doubt to prove Racketeering Acts 8, 12, 14, as well as counts 6 through 9. The defendant's Rule 701 argument was unavailing. Jane Doe number 11's testimony about her interactions and communications with the defendant and about her own medical status is not expertise within the meanings of Rule 702. Jane Doe number 11's settlement agreement was also admissible. It was evidence of the enterprise and its means and methods, in particular, the efforts the enterprise undertook to conceal and perpetrate the enterprise. Nor was it precluded by Rule 408. While evidence of a settlement agreement to prove the validity of or amount of the disputed claim is not admissible, the court may admit this evidence for another purpose. In this case, the agreement was admissible for a purpose other than to prove or disapprove the validity of the claims that the agreement was meant to settle. In some case law, whatever. As discussed above, the agreement demonstrated the defendant's efforts to conceal the enterprise and was thus admissible. Wow. Okay.
So there was absolutely no proof that this discussion happened between her and R. Kelly.
Oh, wow.
What else was there not proof of? She said that she had told him that she contracted the disease and then she got a settlement. The settlement did not address that at all.
Yeah, let me just point out the only evidence they really had was from Azriel. And there was emails, text messages from her saying that she said this, she said that. That's all that was. That's it.
But did they have the medical records or present his medical records that he was positive?
No. His medical records said that the
results were inconclusive.
No, it was negative. It was negative, and the guy said it was inconclusive because he said based on him giving him the medication and what he observed, that's why he said that he had herpes.
Wow.
But the medical report itself, he didn't go back and do another test like a blood test. Medical report said negative.
That's crazy.
He said
Perspective, can you finish? I gotta do something real quick.
Yeah. Go ahead, Sylvia.
But I'm saying he said that it was inconclusive. And now you gotta also remember, Purple Couch. This doctor was not getting paid by Robert. The way he was getting paid was by getting free tickets to the concerts and stuff like that. So he did have his own vendetta against Mr. Kelly because the stuff that was going on, these people, it was unethical.
Wow.
You're gonna be a doctor and don't have medical records of everything of what you did, and you was doing things that was not part of your forte, your within your guidelines of being a doctor. That's why they said they were going to do a investigation on him.
And the thing too is that, okay, so you prescribed him medication. Was it based on an outbreak? Because you just don't give someone
He said he was
medication.
doing it regularly. Even he would just. He said he knew the pharmacy so bad that he memorized the phone number.
Wow.
So he didn't even see the patient.
No, he wasn't seeing him. So what he said was Robert initially said that he had an irritation from some leather pants that he wore with no underwear.
Yep.
And from that, he did the test. And then if Robert called and said anything was wrong, he would just prescribe it.
Yeah, but the actual test he took came back negative. And this is the same test that Cardi B took, and they said it was sufficient in the courtroom. So how come it's sufficient with Cardi B's case, but not sufficient in this case? It doesn't make sense.
It doesn't make sense at all.
Go ahead.
Okay.
Go ahead.
Okay, so the government moved to admit evidence that the defendant had sexual contact with Jane Doe number 13 in 2006 when she was a minor. According to the government, the defendant met Jane Doe number 13 at a concert when she was 15 years old. He began a sexual relationship with her and directed his associates to arrange Jane Doe number 13's travel to visit him in Chicago. The request was granted. Mind you, I need to know how a 15-year-old got tickets without parent.
This is the thing I can't understand, perspective. I don't understand how this is happening. How can you travel across?
Can anyone in the chat give me an instance to where they were able to book tickets for a minor without a parent? Give me an example of that, because I'm not understanding.
I know when I had kids that was little, my kids are grown now, right? But anytime they were traveling, I had to be the one to pick it up, to purchase the ticket, and I had to be there to show them my ID for them to go on to the plane. And then, they have students or whoever would take them to the next destination, have another adult to take them from there too. And they were 16 and 17 years old.
Unless these so-called associates were saying that they were their parent.
Oh, yeah. Okay. Could be that.
And in that case, why didn't we bring in these associates and ask these questions? Okay. The purpose evidence was direct evidence of the enterprise. It proposes in its means and methods. In its purposes and its means and methods. It was therefore relevant and not barred by 404B. The proposed evidence.
Hold on a second. Listen. Candy. Azriel mom bought her ticket, and so does Joycelyn mom bought her ticket at one point. They
You're
said
right.
The parent bought the ticket. So.
Okay. Well, then the next question is, how the heck are these underage kids getting away for this long from their parents' house? Because I know if my baby don't come home overnight, I'm having a fit. I know if my baby goes somewhere, I'm going to call the parent and we're going to discuss the fact that my child is spending the night there.
Unless the kids are not living with the parents.
And even if they're living, they got to be living with a grandma, auntie, something.
Well, there's runaways that live on their own.
So you're saying that he only found runaways, and
I'm just giving an example.
No, I'm not saying you, but I'm saying so every single one. These runaways had money to go to his concert, and so on and so forth.
Well, the mom, Azrael's mom drove her how many hours? 8 hours.
Mm-hmm.
To go see him when he wasn't a fan. She wasn't a fan, huh?
Yeah.
Okay.
Unbelievable.
Okay.
And also at the concert, if you're under the age of 18, you have to have a parent with you.
You have to have an adult with you. Okay. The proposed evidence was admissible under 403, Rule 403. It was probative of the enterprise and no more inflammatory than the charged offenses. The government moved to admit evidence that the defendant had sexual contact with John Doe number one in 2006 when John Doe number one was a minor. The government sought to present evidence that the defendant promised to help John Doe number one with his music career, began a sexual relationship with him, and directed him to engage in filmed sexual encounters with others. There was no videos of John Doe number one. And there was no music from John Doe number one. Didn't they try to say, "Where have you done any music?" And he didn't have any to present. Hey, you guys are quiet.
Yep. Can you hear
I want
me?
to say that the only music that he even spoke of was something that was after Robert was already in jail. But he
Can
had.
y'all hear me?
Yeah, we can hear you.
Okay.
John Doe number one had no music that he had been working on, and there was no films of him, no video. And he was still on social media, big upping R. Kelly, like supporting him through everything that was happening until he got in trouble. Let's see.
And tell the people what was his reason for testifying. What
He was offered a deal
because he was in trouble.
Yeah, he was offered a deal because he called Azriel and offered her something like $50K to go away. But he had not spoken to Robert. This is just something he did on his own. Wait. Didn't
they had a
No.
Hold on, it's on the hearing. Remember the hearing where remember Dr. Rice had the recording of him talking to Azriel in our line? Remember that?
Yes. Wasn't it a deal between the two of them? Between Azriel and him?
Yeah.
Okay. Well, someone else has to tell us.
The government said that they would talk to his trial lawyer, a judge, to get, work a deal or something out, right?
Mm-hmm.
Yes. And then they took his deal away because he wasn't a good witness.
Yeah, but the thing is, you look at his his sentences is after Rob's.
Yeah.
His been postponed, and now his is after Robert's.
Because if they don't, if his happens first and they don't sentence him, then they can't continue to use him against Robert. So they're postponing it. So it looks like there still is an enterprise. Mm-hmm. But during trial, he said the only reason he was there was because they offered him a deal to testify.
He got a plea deal. He's the only one that hasn't been in jail yet. Because Michael Williams is in jail, and he is appealing his case.
Yeah, Michael Williams don't have nothing to do with R. Kelly. They just tied him to that.
And Michael Williams tried to say he didn't have anything to do with R. Kelly. They wouldn't let him talk.
Mm-hmm.
I don't think Robert even knows who he is.
No, I want to say the lawyers addressed that in tweets and said he did not know who he was, but just because he knows someone who knows someone, they tried to pin them together.
Yeah, but Michael himself on the call, he was trying to tell the judge, hush him.
Okay. The government moved to admit evidence that the defendant had sexual contact with John Doe number one. I already read that. The evidence was direct evidence of the enterprise purposes, as well as its means and methods. The indictment charged, among other things, that one of the purposes of the enterprise was to produce pornography, including child pornography. Thus, the evidence was relevant and not barred. There was no child pornography showed. None. Finally, the evidence was not unduly prejudicial and was no more inflammatory than the charged offenses and did not raise other Rule 403 concerns. The government moved to admit evidence that the defendant threatened employee number one, a talent manager, and that he entered into a settlement agreement with Jane Doe number 15. In particular, the government alleged that the defendant met Jane Doe number 15 through her talent manager, employee number one, when Jane Doe number 15 was 17 years old, and that the defendant promised to act as a mentor to Jane Doe number 15 in the music industry. So Jane Doe number 15 did not come in and testify to any of this. She refused. So only employee number one is speaking on what she is alleged to have happened with Jane Doe number 15. And employee number one is Cheryl Mack. Employee one, when Jane Doe number 15 was 17 years old, and that the defendant promised to act as a mentor to Jane Doe number 15 in the music industry. The government also moved to introduce evidence that Jane Doe number 15 subsequently accused the defendant of sexually abusing her, that the defendant threatened and intimidated employee number one, causing her to sign an affidavit falsely stating that she did not witness the defendant doing anything inappropriate to Jane Doe number 15, and that the defendant reached a financial settlement with Jane Doe number 15. In supplemental briefing, the defendant argued that the evidence was needlessly cumulative. The government's request was granted. Do you guys want to mention anything about Cheryl Mack? No? Okay. The evidence.
I'm at the. I had to run to the store, so
Okay.
Yeah.
Anything about Cheryl Mack, Sylvia?
Would you like me to? What was the question? I'm sorry.
I said, did you want to say anything about Cheryl Mack and her what she is saying?
Well, Cheryl Mack is the person that was working as assistant for Robert Kelly, and she supposedly is the one that had talents that she brought to him, and she felt that he was not recognizing her bringing those people, so she felt slighted, and her son is, of course, London on the Track, and sorry, Purple Couch. Oh, they zapped you, Purple Couch. They're trying to get that person. They zapped you by accident. That person's right over top of you. That man.
Oh my.
Frank, they zapped you by mistake because it must have jumped.
Oh, okay.
So, and also Cheryl Mack definitely is the one that they use the transcript for her story for the surviving R. Kelly. So with her,
you know what I don't understand with Jane Doe number 15, how she was able to deny coming. She was the one who was able to escape coming to testify, whereas everyone else who testified said they did not want to come and testify. They did not want to be there.
But she did. She wanted to. Oh, I want to give a shout out to Harper Blue. Harper Blue. Someone put her link in there. She also does and also Purple Couch. Y'all need to go subscribe to my beautiful people. Purple Couch and Harper Blue. Put Harper's link in there, guys, and Purple Couch. Put her link in. Because she's been very diligent in this channel. You guys need to come and visit her because I was there the other night and you guys did not show up. I don't like that.
Sorry.
They don't show up.
I actually am subscribed.
Yeah, when the family goes on an outing, we all go on an outing together. Okay, I don't leave anybody behind. When we say field trip, everybody goes over there for the field trip. All right, sorry. Okay, I had to put in a little commercial.
So how is it that this talent was able to not come in and testify, but they were able to force everyone else to come in and testify? What do you guys think about that?
I don't know. But you see what Dominique did? She didn't come. They tried to force her butt, but she's like, oh no, she leaving. She ain't.
But I mean, just thinking about the fact that Geronda is doing her lives now, saying they're forcing her to come to something else. Why are they forcing some and not forcing others?
They making all of them, except what happened is, the other ones call them bluff. It's on. Look, like if you gonna catch me, you won't get me. If they don't get served, they can't make them come.
And they probably are not going to be of any use to the narrative they're trying to,
Okay.
paint.
Well, considering they're allowing Cheryl Mack to tell her story, you would think that they would force her to come. How is it okay that someone else is telling someone else's story?
True.
Okay.
Yeah, this whole thing is just tripping me out. Totally. I'm just
Let me
bewildered.
tell you something. You know how it is when you're a person of color. If they want, they'll get you any kind of way they want to get you.
Tanya,
they make up rules.
Go ahead and take over, Tanya.
Yeah,
Take
one thing
over.
I can say.
I'm at the store, so I don't.
Sylvia,
I had to.
You're gonna have to let me run upstairs and get my charger. My battery just said it's on 2%. So
okay, go ahead. We'll have a conversation while we wait.
Yeah.
Thank you, Black Beauty. Thank you for putting that link in there. Thank you.
The one thing I would say is that my the judge that I worked for, all the law clerks that came through, he would emphasize that they need to educate people of color. He was like, no matter what, educate people of color of their rights, because he saw the disparities in the legal system.
Was he white?
No. No. And he was the judge that I worked for. They tried to block him when he was appointed by Clinton, and they tried everything to block him, being a black man. And they actually did a march on the Capitol to get him confirmed. I mean, it had to go to that extent.
Wow.
Okay. And once he was in, and he was the only black senior judge in that court, and they would always wonder, our cases was rolling. I mean, he was a federal judge. Our cases was rolling, and they would always hear laughter from our chambers. So they was wondering how our cases are getting closed. He didn't have a lot of reversals, but he always kept it light, but always told his law clerks, because we had the most diverse law clerks. The other two, Lily, okay? Lily, you know what goes after that, okay? And so we were the ones that was trying to educate the law clerks who were going out to be attorneys, or permanent law clerks or career law clerks with other federal judges, or wherever they were going to go. And that's one thing that he emphasized because of the disparities that he saw.
Wow. Wow.
It was real. And, you know, a person in the chambers, you hear the whole trial. Sometimes I would go in, sometimes I wouldn't, but we always had to listen to the trials, you know, because if he needed something, if he, you know, we needed to do it, rush in there, give it to him, whatever. But you just see and hear a lot of stuff that's like, what in the world? And to me, to see all of this that was admitted,
But here's the
I'm
thing: I've never seen any case where nothing got dropped. Nothing.
nothing. That's what's kind of tripping me out.
I'm back, you guys.
But I'm really wondering, based on her prior career, why in prior positions, why she did not consider recusing herself from the trial, because they are assigned. They're not, the cases are assigned just like next, blah, 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 blah. It's not a specific, oh, we're going to give this case to this judge. It's assigned through the system. And when it pops up and you see it, you can say, okay, I'm recusing myself, and then they'll give it to the next judge
Mhm.
who's in line. So I'm just trying to understand.
Also, her daughter works for the sister network of Surviving R. Kelly, so I don't know why she didn't recruit.
No, she don't. No, she don't. Don't. Nope.
Oh,
That's not her daughter. Nope. That's
I
not
apologize.
That's not his daughter. Her daughter. One daughter is like a massage therapist, and the other one's a teacher. That's not his daughter. The daughter. Nope.
Oh, that's been circling for so long. I thought it was true.
I nipped that in the bud about a year ago. I nipped that in the bud. I did my research and show exactly, because her daughters went to school with Schumer, whatever. And the woman that y'all talking about lives in DC, and she's married to someone, and she's not. No, that's not her daughter at all.
Okay, I apologize.
You would have had her at age, I think, 15.
Mhm.
No, that's not her. No. And if trust me, if she had an age at that young, it would have been like, oh, it would have been a story about that. But that's not her daughter.
Okay.
Yeah, I'm just kind of thinking. I mean, because there are a lot of times that the judge had to recuse himself, and even recused himself because of the staff, that there was a possible conflict of interest. You know, we would have to say, "Oh, I know them," or blah blah. You know, because there was a case where a bishop was on trial, and as soon as I saw the name, I had to inform the judge, and so it was moved to another judge. So I don't know.
And isn't it strange? I mean, is it normal for the jury not to even say anything?
Yeah, the jury can't say much, but when the when it was presented to the grand jury to bring down the indictment, I wonder. I don't know. I can't believe that no one, even on the grand jury, had not heard of this.
In federal cases, the lawyers don't get to go back and question the jury, right?
No, not no. Mm-mm. They really don't. But my question is, I mean, I just have so many questions till I'm just like,
Now, if you got questions, you work in the court system. Imagine us.
I mean,
Okay.
I'm really bewildered. I'm just concerned. Yeah, I'm concerned. But because she acknowledged, some concern about his attorneys, maybe, she will
So
kind of
if it is gonna go up for a retrial, does she have to be the judge that it's retried with?
no, they can ask for a different judge. No,
Absolutely.
and yeah,
Okay.
no, they can ask for a different judge, and yeah.
I'm gonna finish.
Well, go ahead and finish, and then we're not going to stay much longer because it's almost that football time for folks.
Okay. The evidence showed that the enterprise's means and methods, specifically, it showed that the enterprise's efforts to perpetuate and conceal the enterprise. Thus, the evidence was relevant and not barred by Rule 404, nor was it unduly presidential because it was no more inflammatory than the charged offenses. The government moved to admit evidence that the defendant abused Jane Doe number 18 physically and psychologically. According to the government, Jane Doe number 18 began a sexual relationship with the defendant after one of his associates approached her at a concert with her parent. The defendant then subjected her to his rules. The defendant then subjected her to his rules and punished her, including physically, and he perceived that she had broken them. When he perceived that she had broken them, directed her to write letters containing embarrassing false statements by herself, and directed her to have sex with him and others, which was filmed. The request was granted. Without it, I mean, I don't understand why they didn't present any of these letters. But
Right, the letters, and then if he is illiterate,
so she
did
could have
he
written
read over it?
anything,
Right,
because he could not read what she wrote.
exactly.
But
And how could he instruct
I mean,
her to
he can
read?
talk, so I can understand them saying,
Yeah.
"Oh, okay, he can say do this,"
Do
but
this.
if he cannot necessarily
Check to make
completely,
sure. Yeah.
How does he know?
I mean, he
for sure
can
that's
read,
what
but
she
not
wrote?
a lot. Okay, so this was direct evidence of the enterprise, its purposes and its means and methods. It showed that the defendant's control over his associates and the victims of the enterprise. It also was inextricably intertwined with evidence of the charged offenses involving Jane Doe number 5. The proposed evidence was also admissible under Rule 413 and was relevant to the charged sexual assault of Jane Doe number 4, 5, and 6. Moreover, the evidence was not unduly presidential and otherwise excludable under 403 because it was no more inflammatory than the charged offenses. So you guys have to remember that, or if you don't know, she was arguing with these girls on Instagram and calling them liars every time they tried to come out and say that they were victims or being held. And this was on a public platform that she was calling them liars. So how she was able to flip and then become a supposed victim is weird to me. She was over the years still playing his music on her IG. She was dancing sexually. She was releasing music that we had not even ever heard in support of him.
In support. Wow. And where are all the
So was his ex-wife.
And so was his ex-wife, but she was not in this case. So
where are all these videos?
Yeah, but
they're all on Instagram, and they're collectively between all this R. Kelly sector.
The S videos.
The what?
The
S
video.
So only, I believe, one was shown where there was a few people in it.
Yeah, and he was not even in it.
He wasn't in it.
Interesting, because as we know, the vulgar video was shown in Tasha K. Cardi B case.
Yep.
So why couldn't, as receipts and to shore up this evidence?
Yep.
Where's the beef?
Because there's no beef. It's chicken.
Wow.
But just like Bunjin said, they were overloaded with just so much of it that it's like, could he possibly be innocent when there's so many people saying this?
Right.
But there was nothing substantial in it.
Wow. It was a lot of hearsay.
All
And
hearsay.
a lot of
Right, and not even in hearsay, and not sometimes circumstantial evidence, but that's not even a lot of circumstantial evidence. It's a lot of hearsay.
And then this man's fighting for his life, and they take it so lightly and just using anything they hearsay just to convict him. That doesn't make sense to me.
Wow. Wow.
Okay. The government moved to admit evidence that the defendant directed a former girlfriend, Jane Doe number 19, to sign a non-disclosure agreement and to write text messages containing embarrassing false statements about herself, and that the defendant made vile threats to her and her family. Where are these threats? It says the request was denied.
But here's the thing. The other thing too, I was gonna say, where Purple Couch, they were those witnesses, the so-called victims, they were found that there were inconsistencies in their testimony, lies.
Wow.
The judge even threatened to impeach Azriel.
What?
Yes.
Wow. A lot of this should have just been stopped.
Okay.
Jennifer has a lot. She has a lot that she can pull from.
I'm gonna rush through this page so that we can let everybody go to the game.
Okay, go ahead.
The proposed evidence was needlessly cumulative. There was other admissible evidence of the enterprise's means and methods. The government did not explain how this conduct related to the enterprise. Bribery of a Cook County clerk. The government moved to admit evidence of a conversation between the defendant and a crisis manager after the release of a television show about the defendant, and while law enforcement was investigating the defendant. According to the government, the crisis manager told defendant that he had two people who knew a lot and that the defendant should figure out what you can do for them. The defendant responded, "What do you mean, man? What do you mean, man? Is write something on a piece of paper and give it to me. What I should tip the bailiff, what I should tip the valet. Like when my uncle come up here and say, Rob, the valet guy, he parked the car over there. I say, so what should I give him? He say, well, $20, $30. I gave him $30. So what I'm saying is I don't know the number." Okay. The crisis manager also told the defendant that he had paid a clerk at Cook County $2,500 and given the clerk a burner phone to communicate information about the ongoing investigation. So why is this not the crisis manager's charge? Because at this point, it doesn't say that Robert did this. It says the crisis manager told the defendant that he had done it. This sounds like the crisis manager bribed someone.
Right. Witness tampering. So, wow.
That has nothing to do. I mean, it has something to do with Robert, but he did not instruct that.
Right.
He was told about it. But she denied it anyway. But the burner phone communication information about the ongoing investigation, the crisis manager said that's done. You don't know nothing, in which the defendant replied, exactly. According to the government, this conversation was evidence of the defendant's willingness to bribe someone. And therefore was probative of the continuity of the enterprise. The request was denied. She denied that one. The proposed evidence was marginally relevant because it went to the means and the methods of the enterprise undertook to conceal and perpetuate itself, but it was too tenuous to be admitted. While the evidence demonstrated the defendant's willingness to bribe someone, there was no proof that he actually followed through. For those reasons, the proposed evidence had the potential to confuse the jury and was not admissible. He did not bribe anyone. He was told about it.
After the fact.
After the fact. He did not even give the money to pay that person.
Wow.
He was told what was given.
Wow.
And this is by a member of his law team, essentially, because he was hired by his lawyer.
My goodness.
So I don't know.
Wow.
It seems like they just were trying to put every single thing that anyone did around him on him.
Right. Oh my goodness.
Sylvia, we are on page 14. Would you like me to keep going?
No, because we got 5 minutes.
Okay.
All
To
right.
be
So
continued.
much I wanted to say in this store. The people are looking at me crazy. I had y'all
Well,
muted.
say it loud. You are Kelly defender and you proud.
Yeah, I need a t-shirt on. Oh my God, this is crazy.
Wow.
Fit in a little bit of what you wanted to say.
Going back to, even though she didn't allow it to happen, just think about all the stuff that they were trying to put in. Like, what did that have to do with him? He wasn't the one that paid the person or
Or
made the
said go do that.
suggestion.
You're right. That's crazy.
You guys,
So at the end of the day, free R. Kelly.
we are Kelly.
Free R. Kelly.
Oh yeah.
I gotta play my Free R. Kelly song. That's a good
Goodness.
note to stop on. Hold on, let's do our Free R. Kelly song by Peter.
You know what's crazy is that most people, like you, Miss Purple Couch, I don't know where you stood with this to begin with, but most people don't even know even a inkling of what actually happened. Because my client I had yesterday, she's the district attorney for our county. And she even said yesterday that I was asking her, we were just having a brief conversation, and she even mentioned when I was asking her about it, her response was, well, they said he did that. I'm like, but that's hearsay. You know that. You're the district attorney. She says, well, I'm going to have to look into the case because what I heard was, even though she's never looked into it, well, they said he raped such and such girl and just all kinds of stuff she was saying. And I just quit talking to her about it because, first of all,
Well,
you're
don't
DA
stop.
and you're talking to me about you heard, they said.
Yeah. Initially, I mean, even with the 2 documentaries, I really didn't watch either. I, at first, because everybody's like, oh, I turned on, I couldn't watch the rest because I wasn't feeling it. Some of it, I don't know. But I really, what bewildered me, and I use that word a lot because that is what I feel, was when it was the racketeering charges in this enterprise. And I'm like, what? How do you build that up? Rico charges. How do you build up to this? And
So most people don't know what he was charged with, nor what he was
right,
convicted with. They think it's
right,
just rape or molestation, and
exactly,
that's what I hear from
exactly.
most people that I talk to about. I said, but did
Right.
you know that he was convicted of Rico and the Mann Act? And it
Yeah,
was like, what?
exactly.
Yeah, if you're going to charge him correctly.
Right.
Don't
Right.
cheat to get what you want. If he did
Yeah.
something, you don't have to go through these extremes to prove it.
Total extremes. That's why I was like, and
You
that's
just
what kind
state
of
the facts.
right. And present the case. But I think that's what hung me up, and I'm like, okay, something really doesn't
I feel partly
feel right.
responsible for bringing you to the other side, Miss Purple Couch.
Huh?
I said I feel partly responsible for helping to bring you to the other side.
Well, I never was on the other side. I just really felt that this something just wasn't right, even from the documentaries. That's why I didn't finish watching them. Because I don't know, I just felt like it was overkill or something. And but the thing with me was that when I knew that he was being charged, but when I found out what he was being charged with, that's when I was like, okay, that doesn't even match. You had this run of a meal of these documentaries, and like T. Jones said, everybody is thinking that it's based on those documentaries, the charges,
Well,
and it's
when she
like
left me,
totally. Mhm.
yeah, sorry.
No, go.
No, I was just saying when she left me yesterday, she said she was going to look into it because she didn't know all of those things.
Right. And then,
She,
and I still was just kind of like, this is crazy. And then when I found Miss Sylvia's page, and I told her it was just that Rico thing, and I really didn't even pay attention about the Mann Act. I was like, what? And the Mann Act too? So then I'm like, okay. So what I was feeling, it was just unsettling to me. I couldn't be on, he's, guilty, guilty, guilty. I just couldn't go there. And now I understand why.
I remember you were on Sylvia's panel and I asked you in the chat, do you believe he was guilty or innocent? You were like, well, you're not going to like my answer. And I was like,
No,
oh,
I never said you're not gonna like my answer. You might have the wrong person.
Yeah, you had the wrong person. That was
Yeah.
Lisa that said that.
Yeah, that wasn't me.
That was Lisa.
Oh,
No, that
I'm
wasn't me.
sorry.
No problem.
That was Lisa. No one they say, oh, she says, well, okay, wait a minute.
I think you guys both were on the panel that day. That's why.
Yes, we were. We were. Yeah.
Okay.
But Lisa said, well, let me, you'll win me over. Let me just ask you this question.
Well, she's the one I feel partly responsible for getting her. I'm like, yeah, bring her over.
Yeah. Miss Sylvia just helped solidify what I was feeling.
And they've been dogging me out over here, Miss Purple Couch. They've been dogging me out here because I've been trying to bring the folks that were against Robert in there. But no, you should see how they dog me out. They leave my channel. I'm talking about.
I found a scripture for you for that, Tiffany. Not Tiffany. I found a scripture for you, Sylvia.
I'm talking about the R. Kelly sector here. They dog me out because I have people that they're not believers. I have to warn those.
The scripture for that was about Jesus having dinner with the taxpayers, and then him telling them, I have to speak to the people who need me, not the people who are already here with me.
Woo! Preach.
Mm-hmm.
Go on, preach.
I can't remember the exact words. I posted it on your page. But yeah, I mean, if we're already here, obviously the ones who need the message are the ones who are on the other side and need to learn.
Yeah.
Mm-hmm. And one way or the other, eyes will be open, and and sometimes it just takes people time.
Yeah, and don't beat up on people. Let them take their time to learn, and we can teach them. I'm a patient teacher.
Exactly. And like I believe it was T. Jones who said, sometimes you just have to use your common sense. Everything is not straight line, legal jargon. Because jurors aren't familiar with legal jargon. They're having to deduce from evidence and what's presented. Mm-hmm. So You have to use common sense.
Yeah.
And when stuff don't add up, when somebody say 1 + 1 = 4, then you got to say, oh no.
No, we got to use the black lawyers saying, if it don't fit, we must
You must.
acquit.
Oh goodness.
Yeah. All right, good people. Let me do my Peter, and then I'm about to get off this live.
Okay, you all be blessed.
All righty. Thank you for stopping by, guys.
Sylvester Galley, I can see you walking out through that open door. This is for Robert, Sylvester Galley. Make your way and get out to the place where you belong. Just like you, the tunnel empty for the wicked people. Do 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 yo. Do 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 do. Do 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 do. Do 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 do. America, free Macaulay, son of the Most High. Standing up for Robert Kelly. Africans, stand up for Kelly. Jerusalem, stand up for Kelly. Free Macaulay. Standing up for Robert Kelly. Africans, stand up for Kelly. Everybody, Jerusalem, stand up for Kelly. We are free Macaulay. This is for Robert Sylvester Kelly. God has heard your cry and has come to change it all. It's not been easy from your beginning. From your foundation, God is gonna walk it all right. Hey, you liars, will Lord you Kelly, to the betrayers there, do 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 yo. Do 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 do, hey, do 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 do, hey, do 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 do, hey, America, no way, free Macaulay, son of the Most High. Standing up for Robert Kelly. African, stand up for Kelly. Jerusalem, stand up for Kelly. Free Macaulay. Standing up for Robert Kelly. African, stand up for Kelly. Jerusalem, stand up for Kelly. Everybody, free Macaulay. Freedom for Kelly. Freedom for Kelly. Oh, oh, oh. Freedom for Kelly. Freedom for Kelly. Free Kelly. Son of the Most High. Oh yeah. Do 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 do, eh. Oh yeah. Do 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 do, eh, eh. Do do do, eh. America. Set them free. Set them free. Do do do, eh. Set them free. Do do do, eh. America, free our calling, Son of the Most High, standing up for Robert Kelly. Africans stand up for Kelly. Jerusalem stand up for Kelly. Free my Kelly. Standing up for Robert Kelly. Africans stand up for Kelly. Jerusalem stand up for Kelly. Free my Kelly. Standing up for Robert Kelly. Africans stand up for Kelly. Jerusalem stand up for Kelly. Free my Kelly. Son of the Most High. Why idea? Set him free, oh. He's my brother. He's a good man. We all love him in Africa. He's touched millions of lives. Robert Sylvester Kelly, congratulations. You're out. You're out, man. Thank you, Jesus. Okay, ready? So Lord, hold on now. Wait a minute, fellas. Wait a minute. I think it goes something like this. Whoa. 1, 2, 3, 4, 5, 6. Can somebody take these burdens off of me? Off of me. Can somebody take these burdens off of me? Off of me. Cause every time I turn around, there's something trying to keep me down. Can somebody take these burdens off of me? Off of me. Whoa, can somebody take these burdens off of me? Off of me. Can somebody take these burdens off of me? Off of me. When I look up, don't you know, burdens knocking at my door. So won't you come and take these burdens off of me? Off of me. Oh, come and take these burdens off of me. Off of me. Somebody come and take these burdens off of me. Off of me. Soon as I get up off the ground, my burdens knock me right back down. Can somebody take these burdens off of me? Off of me. Somebody take these burdens off of me, off of me. Somebody take these burdens off of me, off of me. Somebody take these burdens off of me, off of me. Well, off of me, off of me. Oh, off of me, off of me. Well, off of me, off of me. Get them off of me, off of me. Come and break the chain. Come and break the chain. Get it off of me. Get it off of me. I need somebody. I need somebody. I need somebody. I need somebody to get this burden. To get this burden. Can somebody take these burdens off of me?